Thank you, sir. May I now please request Dr. Ayon Kumar Tarafdar to share his valuable insights on the same.
Very good morning to all of you, to our director, registrar, the guest of honor, and other dignitaries on the dais, all the participants, the deans present, students here. A very good morning. This workshop is significant in many ways. I'll try to explain in few words. In our institute, we are mostly dealing with architecture, planning, and to a certain extent, engineering also. Many of the things which we do in our studios and which we teach and which the students work on, mostly our minds are tuned towards thinking them as solutions to problems, real life problems, and we get trained how to solve those problems. But in that process, we teachers realize many times, and also students, you also realize, while designing those problems architecturally or in terms of planning or engineering, we sometimes evolve processes which are new, which are innovative, which are research oriented and has not been used in other places. But unfortunately, many of these ideas remain in our thesis books, sheets, and at the most as published papers. But sometimes some of these ideas have a lot of potential. There might be some community out there, some household, some person, or an organization willing to adopt these ideas and even willing to pay for it. So it's important for us to think of what becomes intellectual property, what needs to be conserved, protected, and ownership has to be taken. So this kind of a workshop raises that awareness and our understanding of how to identify what is suitable for a patent and how to go about and then protect its ownership because it is created by someone. And unfortunately, many of these good things which our students do and professors work on and guide them and help remain in maximum of journal papers, which is only a, a property right of those pages and words. It sometimes does not reflect into products. And there are many institutions who take ideas from these published papers and develop the products. And the original people who generate these ideas lose out. So it's important for us to understand this whole concept of IPR and patents and the process behind it in our country and work towards it as a goal. And if I also believe if we have this as a goal to have a particular patent in my name or in my student's name or as a student also, it has another benefit. So it helps us to think innovatively because once you get into that mode or get attracted towards this concept of I should have a patent, then you'll realize that it's not easy. You have to innovate. There has to be an element of newness in it, and then you start working towards it. So it has a lot of benefits, and I think this workshop will be fruitful to all those who have registered with four very interesting speakers. So I believe all of you will have a worthwhile time. Thank you for coming, registering. Welcome all of you once more.
Thank you, sir. May I please request Mr. K.V. Uma Mahesh Rao, sir, our Honorable Registrar, to share his kind thoughts on the occasion.
Respected Director Sir Ramesh Sir, Rao Sir, today's the program is organized by him. I am Sir, today's guest, chief guest, and others on the dais, my dear faculty, deans, and my dear students. This is in fact a very, very interesting topic. This has been selected by our librarian, Sir. Really, I appreciate his thought on this. Because I go back to my memory, once in 2015 or 16 somewhere, I attended an interview at Visakhapatnam, that is Indian Institute of Petroleum and Energy. So when we go for the interview of a registrar or deputy registrar, anything like that, it mainly interview goes on labor laws, service rules, charge sheeting, and how to defend the court cases. This is our pattern of interview. Generally, it matters. But one gentleman, he has asked me, is from IIM Bangalore. He asked me one question. Can you tell me what is intellectual property rights? And I don't know, honestly. I lost my face. Said, sir, honestly, I said, sir, because they are all highly intellectual people. We cannot bluff them simply. I said, sir, really, I don't know. No, just think of, you club the words intellectual, property, right, all those things. You think something. Why should I bluff you, sir? I don't know. Then you know what is patent and what is trademark. Sir, I know, but I cannot define. So this, my memory, when I have seen this program is being conducted here, I encourage all my colleagues and all the people to go and participate in this, because this type of questions, no, that nowhere we will get an answer out of it. Out of their experience, our speakers will explain this. And I had a brief idea is that it is the gauge of your intelligence, intellectual property right. See, this pen belongs to me, the speaker belongs to me, it is your belongingness. But your brain, how you will measure. So that is your intellectuality. The patent is given for a particular period because of your intellectuality. You identified a new item. A patent is given to you on that. It will be for a fixed period of 3 years, 5 years, whatever it is. So it is the appreciation and the recognition of your brain and your ideas. So that is what I finally understood. And that day I really felt very bad that after so much of years and so much of education, I don't know that word. I could not define it. So this is a very great opportunity for all of you to learn about what is this. And thanks to all of you for participating with Jill. And I hope definitely it will be very informative to you, and it will boost your knowledge in this particular field. The patency BATA, it is a trademark. BATA word we cannot use anywhere else. So all these things, if we go deep into it, and our speakers will explain you. Thank you very much. Wish you all the best for the meeting.
Thank you, sir. I kindly request our esteemed director, Dr. Ramesh Rikonda, sir, to share a few enlightening words.
Thank you. Good morning to all. Distinguished chief guest is to come. I think this is what already mentioned by our Mr. Rao, Dr. Bharat Suryavamsi, and respected guest of honor, Sri Sudha from Visakhapatnam, and Mr. Y.S. Rao, registrar and deans, faculty members, HODs, all other students, and as well as registered persons here, and even including my very good friend, Mr. Ramesh is also here. He is a fraternity from engineers. He holds so many feathers to his cap. So welcome to all to this inaugurative session for this workshop, Intellectual Property Rights and Patenting Strategy. See, one thing what we have to know about this is one important item which everyone who is in the field of academics, innovation, and as well as the research, they must know. Unless otherwise, whatever the iota of innovation you are making, your name is there on that, which you normally may not really just bet for it. Even including thesis or research, whatever work we do, we use it to refer certain things. Immediately we give the reference from where we are referring it. That itself tells that one we are acknowledging somebody's great work, what they have done. From that, we are going to learn certain things. We are acknowledging it. Because in our institute, you know very well, we have B planning and B architecture and PG programs as well as PhD. All the places, everyone, every project, every session also end up with certain studio projects. Everything is innovative and a new thought process and thinking and giving the solution to the problems. And the way when we are going to give the solutions to the problems, we also question the problem, how the problem at all arises. That's where the iota of research involves. When the research involves, then strategies, a new thinking, new thought process, innovation is going to get it integrated in your mind, and you deliver a product. The product of that, it may be a strategy, it may be a product itself, it may be our new innovative thinking. All items, it is your item, your property. You have to have a right on it. In case somebody uses, then that becomes, they should not claim it is yours. Once it is yours, it is yours. Especially in India, you know it very well. Swadeshi science is really a great thing what we have. So many people, they may not be claiming that is my own work. They just leave it as it is. But somebody may claim and then they can get a right on it. Copyright, patency, and IPR rights. That's for that, it is essentially to know all the students and faculty and researchers. The work what they are doing, it is their work and it should be acknowledged. The acknowledgement of your work itself is one way you can see these IPR rights. SPA Vijayawada has got Design Innovation Center. We are doing the design related product based items. Already we have got the patency of almost 9, if I am not wrong. Recently also we have just 3 patencies we have made it and we have registered it. One is the leaning on, and also another great product we are going to design it, that is the bus body, especially the facade and the front side, how it has to be designed. For almost like 250 buses of Andhra Pradesh, they are going to use the same design which we are going to give. That has got a kind of an iota of, especially in terms of understanding about it is a combustion, engine, movement, aerodynamics, and all the things, the visual appearance, and then a kind of a body which we are going to make it. It really moves when a rolling load is making it, and then how it really avoids even at the crash situations also to protect the surface, to protect the body of the entire bus. See, that is the kind of a product we are developing. And already we have got the patency for the leaning stand, which recently we have made it. Means a person standing like this, what will be the comfortable item where I can able to get certain supports and then I can feel it more relaxed. Instead, we are waiting for hours together, or maybe sometimes we are waiting for something like when you wanted to wait while standing, how do we lean in, how comfortable you will make it to you on the basis of the ergonomics, on the basis of the anthropometrics. So there is a science is involved, iota of interest and innovation is involved. All the things we are making it, but where else we should know how to register, how to make that particular product is ours. This is where we can understand this kind of a workshop, what we are conducting it. It has got a lot of significance. I really appreciate Dr. Y.S. Rao. Already he has done a couple of conferences in the same line. But every time, every year, it should be really conducted. And this kind of an idea and clarity about the IPR rights should go to the students and as well as the researchers and the faculty. All persons are doing research, innovation, and product design. Even in a strategies, the kind of a new strategies, what you really bring it to your day-to-day life or in your studio projects or any other project is given as a challenge to you where you have brought some innovation that you have a right on it. That is a copyright. Even for a research or a thesis, when you submit it, we will ask you to go for the plagiarism. Reason is we want a original thinking. We want your product. You want your way of thinking and bringing a new ideology for the research and any kind of a work, whatever you do. Unless you put up the plagiarism check, 100% or certain little percentages where in the review of literature you have to refer certain things. Of course, that review may take some extent of the plagiarism. That plagiarism means you are repeating certain things like what others have done. So such things you have to take a base and then you will go in that different direction where you can able to bring your research. But this is one important item, and I'm telling you, I really feel that everybody must throw a light and understand and try to think that wherever you have done innovative items, innovative products, innovative strategy, innovative design, those things you should have a right on it. How do we really tie? How do we really claim a right on it? That is one important thing. That's where this particular workshop give the kind of guidelines and thought process and the knowledge it will give to us in this. It is 1 day workshop, I think. Yeah, in this 1 day workshop. Of course, workshop is the starting and starting of thinking about it and knowing about the matter what we are really aiming for. That is property, intellectual rights, and the patency. I hope this is going to be very much successful. It will reach to all registered candidates as well as the faculty and the staff, and even including the students. Wish you all the best. Thank you very much.
Thank you, sir, for your inspiring words. It is indeed a special moment for us to express our deep gratitude to all our esteemed guests for their presence here with a small token of appreciation as a small gesture to convey our immense respect and admiration. I request Dr. Ramesh Konda sir to kindly honor our guest with a small gesture of gratitude. Once again, a wholehearted thank you to everyone for your presence. Moving on, I kindly request our honorable guest of honor, Ms. Srisudha Senati, to share her valuable insights on the topic.
A very good morning to one and all. Firstly, I would like to thank SPAV for this wonderful opportunity and making NRDC part of this wonderful event and emphasizing the importance of IP. As you are aware, IP is a fast growing field. The reason is that it plays a very important role in the economic development of the nation. Do you know that IP is one of the most important parameter for the global innovation index of a nation? So that is considered the nation's global innovation index is calculated by the IP parameter. And nowadays, if you see the most developed nations, if you look at it, they do have they are well aware about the IPR. And also when you take India, we are also with respect to the skills and knowledge, we also knew about IP. But where we are lacking behind, that we need to point. We have to note down. Where we are lacking down is the nations, the developed nations, they knew how to reap the harvest, the licensing of IP from the protected innovations and the copyrighted materials. But we are not able to do that. So today, I would like to stress upon not only the patenting strategy and the different kinds of IP and how to protect them, but we should also focus on like how to commercialize those technology, how to license those IP, not only to get the money out of it, not only for the revenue. By getting the acquisition of IP, what happens is like we are also solving the societal issues. We are taking out a problem statement and then we are coming out with a solution for that. And then we are going into the market and we are solving the issue. That is how it has to be connected. Not only simply the filing of IP. It should not stay with the university or the academia or the R&D institute. It should reach to the people. That's our major goal. That's the reason the university, the institute is emphasizing about the importance and the role of IP that it is playing majorly these days. If you look at not only in the academia, if you look at the traditional knowledge or the geographical indication, acquisition of IP plays a major role. Not only for getting these copyrights and everything, but for the geographical indication, it stays along with us, with India. So in that way, we do have a numerous advantages for getting this IP. So today, definitely, not only I'll give you the presentation about the different types of IP and the strategies for filing it, but I'll also give some guidance on how to proceed with that once after filing, what are the further steps which we need to take. So are we ready with the presentation or fine. Okay then, thank you so much. I will continue. Thank you.
Thank you, ma'am. I kindly request Mr. Pushpinder Kumar to share a few words on the topic, please.
Good morning all. Thank you Director Sir. Thank you Librarian Sir, Vayasrao Sir. And thank you Dean Academics for organizing this event. So in this event we will discuss about how to proceed for a design and how to file the patent during the session. Okay, so I will show you some examples how to proceed for the design patenting and how to proceed for the problem solving in the design field. So yeah, this will be my topics in the lecture. Thank you.
Thank you, sir. Moving further, I would like to invite Mr. Vishwanath GS, sir, to deliver the vote of thanks.
Uh, very good morning to everyone. I am honored to be entrusted with the responsibility of proposing the vote of thanks for the National Workshop on Intellectual Property Rights and Patenting Strategy organized by the Central Library. I would like to express my heartfelt appreciation to our esteemed director, Professor Dr. Ramesh Rigonda sir, for graciously providing us with this opportunity and unwavering support to conduct this workshop. Um, I also like to thank Dr. Ayon Kumar Tarafdar sir, library chairperson, for his insightful introductory speech. Additionally, I extend my gratitude to Dr. Y.S. Rao sir, Deputy Librarian, for his guidance in orchestrating this informative workshop for the academic community of SPAV. I extend my thanks to KV Maheshwar Rao sir, Registrar, for his continuous support. I like to express our gratitude to our chief guest, Dr. Bharat Suryavanshi, Ms. Sri Sudha ma'am, Mr. Subjit Saha, and our faculty Pushpendra sir for accepting our invitation and their willingness to share their valuable knowledge with us. Uh, the success of any program is reliant on the active engagement of its participants. We express our gratitude to all of you for demonstrating your interest and actively contributing to the success of this workshop. I want to acknowledge the dedicated and motivated colleagues of SPAV who supported us in organizing this workshop. A special thanks to Mr. Krishna Ramakrishna for their unwavering support. A special mention of appreciation to our IT department, electrical department, and housekeeping department for their extensive support in organizing this workshop. Last but not least, but I like to extend my appreciation to our administrative and financial department and staffs for their continuous support. I trust this workshop proves to be informative, beneficial for everyone in their future pursuits. Thank you once again. Hope this be a informative workshop. Thank you.
Thank you, sir. We'll now be taking a brief break. Please feel free to join us for a refreshing cup of tea. We'll resume the program shortly.
check, 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 check. Hello, check, check. Hello, hello.
ఇప్పుడు ఇంకేంటి మీరు ఇస్తే నేను చదివా. మీ పేరు కూడా ఎక్కడ లేదు దీంట్లో. Good morning once again. Our guest of honor, Miss Sri Sudha Senathi, Assistant Development Engineer, Business Development from NRDC, Visakhapatnam. National Research Development Corporation, Department of Scientific and Industrial Research, and Ministry of Science and Technology, Government of India. She is going to deliver a lecture on intellectual property protection, innovation, management strategy in academic research and development. Now I request you to deliver a lecture, ma'am. Thank you.
Thank you, sir, for the kind introduction. Welcome back. So, myself, Sri Sudha from NRDC. I'm an assistant development engineer. So, I do have around some 7 years experience in technology commercialization, technology scouting, and productization. I was been a facilitator for NRDC and Ministry of Heavy Industries, and I am one of the member for the AP startup, for the screening committee member for getting incubated into the startup AP. And also I do mentor innovators and startups for the commercial growth. So before starting, I would like to ask one question. Have you heard about NRDC earlier? Genuine answers, please. Okay, quite a few. Fine. Thanks for letting me know. So we are in technology transfer organization. It's under Ministry of Science and Technology. It's a Section 8 company established 1953. So the main mandate is we promote, develop, and commercialize the technologies. What do you mean by that? That means in the laboratories and in the R&D institutes, they do develop the technologies. But what happens later after the development? Somebody has to take the technologies to the market, to the industry, right? So somebody has to play a role of a catalyst. So we being NRDC act as a catalyst between the industries and the R&D academic institutes. So the R&D institutes develop the technologies and we take the technologies to the industries. For example, let's say if somebody of you are interested in to start a company on building materials, right? Since you are in the similar field, I'm giving that example, but you don't know like what are the current advancements happening in India, what are the advanced technologies available, and what kind of potential that does material has. So somebody has to guide you in that way, right? Before starting ahead. So if you approach NRDC, we will let you know what are the advanced technologies available in that particular domain, in that particular sector, and we will give you the details, technical details. For example, before starting, what kind of parameters do you require? You have to know what is the project cost, whether the project cost is feasible to you or not. What kind of market demand or potential that the material or the production facility has, or the manufacturing material product has. So we will give you the information related to that particular technology, and you can further decide whether you can go ahead with the technology or you can choose some other technology. So that's what. So here there is a gap between the industry and the academic institutes. So we bridge the gap between the industries and the R&D institutes. So we do have technologies in mostly all these domains. Except IT, you can find our technologies in these all streams, like biotechnology, aerospace, you name anything. It can be mechanical, industrial and chemicals, instrument devices, electrical, drugs. You name anything, we do have all the technologies available in these domains with us. So we do have a database of nearly 2,500 technologies, and till date we have transferred more than 5,000 technologies to different industries and MSMEs and startups till date. And we have filed around some 2,000 patents, and we have supported around some 10,000 startups till now. So being a technology transfer organization, NRDC has also we have a mandate of facilitating the IP. What do you mean by facilitating the IP? Facilitating the IP not only technically, but in terms of financial. For example, if an innovator or an inventor come to NRDC for any IP assistance, we not only guide them technically, but we also provide financial assistance for filing of that particular IP, and we don't charge anything. It's a Government of India scheme. So if you approach to NRDC for an industrial design application for a patent, we do conduct a preliminary search, and we will guide you in filing of the particular IP and protecting that IP. That is one of the other mandate of NRDC. These two are the major mandates of NRDC. One is the technology transfer commercialization, and the second one is the IP management, IP facilitation. These are the two important mandates of NRDC. And moving forward, these are the some of the institutes which I have named here, whom we have provided. And we also have providing the consultancy projects to various government industries and ministries. So the first one is the Ministry of Heavy Industries. With regarding to that scheme, I'll come to you later. And for Startup India, we are one of the nodal agency for assessing the application. Have you heard about startups? You all are aware about startups, right? What exactly? One of the benefit of the startup is we do have a tax exemption. If you are doing out really well, and if you are generating a very good revenue, then you are eligible for tax exemption for 3 years, 3 financial years. But in order to get that, you need to apply for that. And after applying, somebody has to assess that application, right? Whether you are really generating a good amount of revenue, and is it you are bringing some economic development to the nation or not. That has to be studied, right? So that part is taken care by NRDC. We had collaborated with Startup India for that tax exemption assessment, and we do provide that. And apart from that, we do have some types with international agencies like USPTO and EBTC. I think you haven't heard about USPTO and EBTC. Just like IP India, it's an trademark offices and patent offices in Europe and US. So we had collaborated with them for providing the capacity building programs in India to promote the IP in India. And we do often conduct a various programs. So recently also, before 2 months, we have conducted one program with USPTO in Visakhapatnam itself. And in New Delhi also, before 3 months, we have conducted one program. And also, even though we have partnered with WIPO Green for identifying some green sustainable technologies, and also for ARDO, not only we should be tied up with the well-developed countries, we should pass on it to the other nations like Africa also. So we provide our Indian technologies to Africa. So we do export our Indian technologies to Africa. For that purpose, we have signed an MOU with African Asian Rural Development Organization. And then we do have a pan-India presence. These are some of our research centers, outreach centers, which we have all over India. You can find it in, we do have headquarters in Delhi and one regional in Visakhapatnam, that is in Andhra Pradesh. And we do have another office in Pune, Guwahati, Bhubaneswar, and Bangalore. We do have some incubation space. Yes. So till now, I have explained you the mandates of NRDC. It is clear to you, right? One I told about the technology commercialization. Second one is about the IP management. But apart from that, being a Government of India organization, we do offer various schemes to the startups and innovators. So what are those? The first one is the technology development and validation commercialization. Sir, YS Rao, sir, I just want to give a clarification. Since today I'm representing NRDC, I'll just only take just more than 3 minutes to talk about the organization. Then I'll be coming back to the IP, our major topic today. Okay. And this is one of the scheme called Technology Development and Validation and Commercialization Scheme. So we are going to grant 1 crore rupees to a single startup. A single startup, we are going to grant 1 crore. So for what purpose we were granting this? So some people, they have come out with ideation and they have developed with the commercialization. But somebody has to support them to scale up the technology, right? To take it into the market. For that purpose only, for validation and commercialization and for the development purpose, we have given this, offered this scheme. And till now, we do have 6 startups who have getting the grant from this TDVC fund, TDVC scheme. So I'll show you also. These are some of the trust areas. If somebody, if some innovator of some startup is working on this particular, in this areas, in this trust areas, they are eligible to apply for this TDBC funding grant of 1 crore rupees. Every year, every year in the month of Jan to March, we do have this applications open for this TDBC scheme. Okay. And then these are the beneficiaries which I am dealing with. So this is one startup, Adivo Diagnostic Private Limited from Chennai. So they have come out with one handheld device for imaging technique to detect the assessment of the wounds and ulcers. Usually what happens for the wounds and ulcers, we need to scan it and we need to wait for some a long period to get to know the result of it. But this handheld device, if you simply scan on your hand where the exactly the wound has been taken place, within a span of 1 minute, you will get to know which area has been affected and what kind of bacteria it is, and what area it is going to expand. Okay, all these things you can know from this particular device. It is developed in. And next, this is the one of other beneficiary from Pune. They have incubated in IIIC, Prayasta 3D Innovations. They are the manufacturing of 3D printed silicone breast implants. Compared to the conventional breast implants, whatever we have as of now, when you compare with the all over the world, those are the conventional breast implants are very heavy, but these are like very lightweighted. These are 3D printed silicone breast implants. This is the one of kind in India which they have come up with. So they are currently in the development stage and they are about to go for testing abroad. We don't have the testing facility in India and they are going abroad for the testing. So this is one of the startup from Bangalore. And this is one of the other scheme which we have, seed funding for the startups for the development of their products and processes. They can approach and we will be granting a seed fund of 30 lakhs. This is another various schemes which do have other for the techno-commercial support. For example, if they want to make a prototype or they want to carry out any testing or they want to do any videos, these are the different kinds of funds which are available for those people. And these are the priority projects. This will be funding will be up to 10 lakhs the innovators will be getting for this funding. And this is one of the scheme which I was talking about, the Ministry of Heavy Industries. So Ministry of Heavy Industries has come up with a new scheme called Capital Goods Schemes. So to support the Make in India program, so they want the indigenous products to be developed. Mostly what happens, imported, we do have the most of the industry 4.0, most of the things have been the new advanced machineries have been getting imported from the other countries. In order to getting indigenized and produced in India, they have come out with the schemes, and we do have around some 35 universities who have selected for this particular scheme. I'll show you a few examples. This is Ministry of Heavy Industries with Sitark, which I was involved in. They are developing a submersible slurry pump in India. This is one of the project. And for Sastra University, they have received around some 40 crores funding for 10 different projects that all related to Industry 4.0. For the development of those 10 projects, they have received a funding of around some 40 crores for the training and for the manufacturing and developing of the particular missionaries in India. So this is all about NRDC. So we do have 3 scientific office sitting at Visakhapatnam. If you want to know more about anything and if you seek any kind of guidance or assistance from NRDC, you can always reach out to us. So mainly, I'll give you a quick summary of the NRDC. It is mainly for the protection of IP in India and abroad. That is the first thing. If you are in need of any kind of technology, if you're looking for any technology, you can come to NRDC and we do have a database of technologies and we can transfer the technology to you. And also at the same time, we can fund you for the technology development. Those are the major things. And also apart from that, The other one is, if you have any technologies and you are not able to take it into the market, everybody doesn't know, cannot do all the things alone, right? You are good at doing the research, but you are not good at marketing, let's say. Then you can approach NRDC and you can assign your technology to NRDC, and we will market those technologies. We'll be having an agreement between us. We will be taking some share from the inventor, but we do help them in commercializing those technologies. This is one of the other service what we provide. So this is all about NRDC. If you have any questions, you can ask me. I'm done with my organization, main services and the part and everything. Please tell me. Yes, the 1 crore funding which I talked about, right? For the phase 1, we'll be giving you 1 crore funding for grant, as a grant. You don't need to return back to us. But in phase 2, if we are going with the same startup, then the 1 crore funding will be equity based. That I have mentioned in my slide also, if you have gone through it. In phase 1, it is, yes, sir.
Yeah, hello, Sudhaji. Actually, I have a couple of questions. One is that are you willing to do the support of patent process also?
Yes.
One thing at that what level actually at the initiation of the concept level onwards, or the complete the including getting the certification or getting the
Yes, sir. Till grant, we will be taking care. Actually, I want to let you know one thing. Initially, we used to take up the provisional applications also. When I come to the type of applications, I'll let you know that also. Initially, if you come up with an application to NRDC for filing of any kind of IP, we will take it and we will conduct some novelty search. That is prior art search, which we perform, and just we will make sure whether it is aligning with the patentability criteria, whatever it is. If it is aligning, then we will take it forward, and we will only bear the cost, and we will give you both the technical and financial assistance, and we will file the application, and we will take care till grant. After grant, renewal part you have to take care.
Okay. Second question is, you're also working on the advertising the concepts or the products, what across it's happening with your association. What is the degree of confidentiality you're going to practice?
We do have a tri-party license agreement, sir.
What
like,
it means?
for example, you are taking the technology from an R&D institutes, right?
Yeah.
The R&D institutes, you approached NRDC, right? So with the R&D institute, with the NRDC and the client being you, we will be signing a tri-party license agreement, and it will be we will maintain the confidentiality with reference to the particular agreement.
Okay, and another small final question is that, so what level actually you are going to integrate with the research institutions? Because if you want to go with the one product, so you are going to involve at the stage of conceptualization, because it will take 1 to 2 years.
Yes.
Minimum.
I'll be covering in the next slide that part. In the end, definitely I'm going to touch on that particular part also. So till now we are clear, right? So now we are coming to our main today's topic, that is IPR. So I'm pretty sure like all of you have at least known about the different kinds of IP, right? Like patents, copyrights, industrial design, GI, right? So I can go with that. But do you know like what exactly we have to file for a patent? For what kind of products we are going with an industrial design? For what kind of products we are going with copyright? Are you aware about it? No, not exactly, right? So let's dive deep into it. I'll go step by step. Okay, first I'll be starting with the patent, then with the industrial design, then with the copyright, and then with the trademark. Okay. If you have any doubts in between, in the end you can ask it, or in between also you can stop me and you can ask me if I'm going too fast. Okay. Fast. So this is the general timeline which I've mentioned here for the different kinds of IP. Later on, I'll touch upon it. See, initially for the patent, what can be patented is a product or a process or a both. Both the product and process can be patented. What can be patented is everything cannot be patented. only as a product or a novel process. Or a novel process matlab it has some patentability criteria that the invention has to be novel, it should include an inventive step, and at the same time, it should have some industrial applicability. If there is no end user to that particular invention, then it cannot be patented. So industrial application is a must. An inventive step compared to the other competitors, you should have come out with some other inventive step. And also the third thing is it should be unique. It should be novel, your invention. For those kind of products and process only the patent will be granted. For not for all the things, all the products. Okay. So we will I'll just brief you and let you know what are not patentable also. So what are the benefits of IP I have mentioned over here. So you will have the monopoly rights, and also you will have the right to stop others from making the similar kind of products. So with your authorization only, he'll be able to do it. Without your authorization, he'll not be able to do it, and it will have some business idea, and also you will have a competitive edge in the market. Since you have a patent, then definitely you will stand out from the others. It's an additional value to your product. Okay, these are some of the benefits which I have mentioned, and you can see like in the year 2023 and 24, there is an enormous growth in the patents grant of the patents, which we can see, which we have not seen in the before years earlier. And also these are the different kinds of patent applications, but I'll not go deep into it and I'll not confuse you. I'll only talk about two things here. The first one is the provisional application and second one is the ordinary application. Why these two things is like, for example, if you have come out with some idea and you haven't executed that. For example, you simply have an idea, but you don't know what is the output of the particular idea. You are still not sure about it. Why? Because you haven't completed the research or you have not done with the testing part. Then you have to go with the provisional application. Provisional application in the sense, it is like a preliminary application that myself, Sudha, I am taking this, I am just protecting my idea in my name, but I don't know what I'll be claiming in the next stage. That is a one kind of provisional application provision you do have for filing a patent. That provisional application has to be filed with a complete application after 12 months. That means the examiner will not give you 2 or 3 years to complete your research. He will only give you 12 months time period. Within a span of 12 months, you have to complete your research and you should come back to your particular starting point about your idea and about the end point, what output you have got it from the particular idea, whatever you have generated, and then you should file an complete provisional application. The complete provisional application is also called as an ordinary application. Ordinary application or the complete application, both are same. I think it is clear. I'm clear, right? If you have an idea and you don't know what is the output of the particular invention, then you have to proceed with the provisional application. If you have completed you have completed your research work and you know what you have generated and what is the outcome of your project, if you're sure about it, then you can proceed with the complete specification. So that is the difference between the provisional and the complete. Complete specification and ordinary application, both are same. Okay. Yeah, ma'am. File it.
No,
No.
not necessary.
Actually, in a patent application, the major thing is claims, ma'am. Okay. If the claims were not included in the patent, then it cannot be completed as a complete application. So for the provisional application, claims are not mandatory. You can give 1 or 2 claims, but it's not mandatory. It's up to you. If you are very sure you have done 70% of your work and you want to claim that particular priority date for your invention with respect to the provisional application, then you can go forward and you can file it.
Ma'am, number one, prior art search is done
Done.
from our side.
Okay.
And we find it to be cleared.
Clear.
The product is also done.
Yes.
The product is in its physical form.
Okay.
The entire process is also documented. But we have not done the strength of the product.
Okay.
Okay, strength of the product or usability of the
Product.
product in real life.
Life.
Then also can we still file a patent?
Yeah, you can do it. You can say it that it is self-validated, self-tested, and you do have some 3 months timeline, right, for getting it published and then going into the examination stage.
Yes.
By the time it reach the examination stage, it's better to complete it. Later on, the examiner will question you, and again he will point out that, and there is an
So which means it has to be complete. What I am talking of as
Yes.
a product, it
Yes.
has to be
completed.
Can I ask you one more question?
Yeah, please.
What is the general time between publishing and getting the patent?
In my
After publishing.
In my next slide, it will be
You
there.
will.
The timeline I have mentioned in the next slide. So these is the difference between the provisional and the ordinary application. In order to not to confuse you people, I'm not talking about the other applications. The other applications which I've mentioned here is international applications, that is called as PCT, Patent Cooperation Treaty. If you want to go file an international patent and you want to file it globally, then you can go for it. No. For example, it will be available globally. Globally, anybody can access your idea, but it is only protected in India, since you have filed only in India, in that particular region. But since you have applied in with Indian Patent Office or else in any other patent office, it is available globally. Anybody can access your data. So once you are going to file, let's say it's a publication or it's an patent, there is no difference. Once you are going out with something, then it's available everywhere. That's the point you need to note down here. It's available everywhere. So that's the reason before going only, you have to make sure like where you want to go and what you want to do with that particular invention. If you want to enter into the global market at a time, it's better to go with a single PCT application all over the world. PCT application means you are filing an application with a single international application. You will choose some few countries and you will go with that. But I just don't want to go in depth with that. Okay. This is the timeline, ma'am, since you have asked. Initially, the first stage is the filing stage. The second one is the publication stage. Filing to publication, it takes around 18 months. And from publication to examination stage, the timeline is 48 months. Okay, but I know what you guys are thinking. We have to wait for this much long time. But now we do have fast prosecutions also. For example, if you have filed a patent on this particular day, that is like 24th November, you can, after filing, after a span of few days, you can go for an expedited examination. Now, currently, we do have the provision for the startups and the MSMEs. We do have this provision. You have to pay an extra fee. Let's say that can be 10,000 for some parties and 20,000 for some parties. With the payment of the additional fees, you will be able to get the publication within a span of 2 months. 1 to 2 months, you'll get the publication. And once after getting the publication, again, you have to go for the fast examination, that is expedited examination. And after that, within a span of 3 months, you will be getting the examination also. That means after filing with respect to the filing date, first date, within a span of 6 months, nowadays you'll be able to get the final result of the patent, whether it is rejected or whether it is granted. Now, earlier days, we don't have this provisional of expedited examination of application, but now we do have that provision. So if you have some patent and you do have some things in your mind that you do have some investors or else you don't want you want to go enter into the market, you do have a lot of competitors into it and you can't wait for 2 or 3 months and this is the right time to enter into the market. Now what you can do is you can simply go for expedited examination of application and you can get to know about the status within a span of 6 months within the date of filing. So that is the current procedure which we have. Not for all the people, but for the few. And then next, after examination, parallelly, you do have the examination going on, and at the same time, you might have receive an opposition from your competitors also. So parallelly, the process will be going on. If there are any oppositions going on, then the examiner will offer you with an hearing opportunity. You have to make sure that you have to let him know that we are we were not copying those inventions and we were doing it our own, and you have to make sure that you're satisfying the examiner. If he get satisfied, then your application will be granted. And after examination, you'll be receiving the first examination report. And after first examination, what will be there in the first examination report? For example, you have mentioned few things, 10 things I have from my product. These are the 10 features which I have done. Now he will come out with a report stating that out of the 10 things, whatever you have mentioned, 6 or 7 are already existing in the other applications. Only 1 or 2 is only novel and the other things are not novel. Then again, you have to come out with your statement stating that, yes, I agree with that, but still there is some difference. You have to manage in such a way stating that my invention is entirely different from that. And again, you have to reply back to the examiner satisfying his questions. Okay. Then if he is satisfied, he'll be giving you a grant, or else the patent will be rejected. So this is the whole procedure, what happens with the patent filing procedure. This is a general flow chart. So I have mentioned about the early publication of a patent, right? So if you want to stop the competitors, then you have to you can go for the expedited publication. So this is what I have explained you: examination of a patent application and receiving the first examination report for the patent filing. Okay. Yes, sir. Yes, sir. Actually, in that cases, the majority while doing the examination is they will go through the priority date only. They'll see like who has come first for filing. Anything, it can be anything. Nowadays, it is online only. There is no physical. But when the other people, that means the real inventor has the opportunity to go for opposition, and he has to prove himself that that's his own invention and he has stolen from this. He will get the opportunity. Yes, 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 yes. That is the opposition procedure. And after that, it is not settled over there. They have to go to the civil court also. There'll be a lawyers, there'll be examiners. So there'll be multiple parties sitting over there and they will discuss over it. Stays. The examiner will give the report, and whatever he has decided, that's the final verdict. Re-exam, not at the initial stage, but after completion of all the prosecutions, he will have the chance. Yes. Yes. At that time also, you will be getting the opposition. Once it is published, then the application is readily available for your competitors to come up with the opposition notices. No one has challenged it. Then the examiner will only decide it. Only the examiner will be the final person to decide about your invention. Some expert. No. He'll be from the patent office itself. Patent office itself. If there is some litigation and that is not settled in the patent office, then it will go to the civil court. Fine. If everything is done, then you have to, you see, like everything depends upon the first examination report, what you receive from the examiner, ma'am. Okay, everything depends whether he is opposing or whether he is supporting your inventions. Everything you will come to know about the first examination report itself. Sir, actually in the first examination report itself, they will give you references of the inventions which is similar to yours. Okay, he'll list out stating that you have claimed so and the other parties have also claimed so and so. Now you tell me, oh, what you have done and what are the other person has done. You just explain me. He will ask you. They file it. Yes. Okay. No, not exactly, sir. It doesn't happen in all the cases. Claiming that it is similar, then he has to come up with a notice of opposition, right? He has to come through only through opposition notice itself, only through the examiner. Then the examiner will be there in between both the parties and he will conduct the hearing. He'll give you the opportunity for both the parties and then accordingly he'll take the decision. Whatever happens with this general law, the similar happens with the civil court in this case also. Yeah, yes. I just want to mention this. It's a very important point you have to note down. If you have come out with some, you have done some research and you have done some development on a particular thing, immediately you should not proceed with any publication or you should not come out with that. For example, you are not aware about all these guidelines and for example, let's say you have already published an journal, then you do have a timeline of 12 months. Within a span of 12 months, there is some time frame given to the inventor to come back to the patent office and file for a patent. Okay, but you have extended. I mean, you have crossed that particular time frame. Nobody can help you again. Only within a span of 12 months only, you have to show that with unknowingly I have done this and I have published in some public domain. Unknowingly I have done that. Please kindly accept my product and invention. You have to request it. That's it. No, not required, ma'am. Only through the examination reports. If, for example, first examination report he has given you, you have written some reply. Still, then also examiner is not satisfied with your answers. Then again, he'll come out with the second examination report. Then again, you have to reply back to that second examination report. Then again, there'll be discussions going on. Then, if you request for a hearing and if you want to discuss something to the examiner, for example, if you want to show a product to the examiner, then you can request for an hearing. That mostly happens through video conferences. You don't need to go to the patent office. Nowadays, everything happens online. Yes. So these are some of the grounds of opposition, like pre-grant opposition, post-grant opposition, that is before the grant or after the grant, somebody can challenge your patent. And so based on that opposition grounds, he'll be giving you an opportunity for the hearing and accordingly he will decide whether to allow your patent or to reject your patent. So this is the what after the filing of the patent, you have to pay the renewal fee and there'll be a time period for every span of 1 year. You have to come up with the renewals of the patent fee. If there is any late payment fee also, they'll be charging you, and you can have the option for that. These are the renewal fees which I have mentioned here. Yes, sir. Yes, sir, for 20 years, and it cannot be extended. Both same time period. No, ma'am, for design it is only 10 years. For yeah, actually industrial design can be renewed, but patent cannot be renewed. That also you need to. No, ma'am. Yes, for the royalty again, that's a different thing, right? But you do have the right with yourself. The reason why they have kept it like being an inventor, you have enjoyed your rights for 20 years, but society, you should not enjoy the rights for the all over your life, and you should share it with other people also, right? In order to do that, they have restricted the time period to 20 years to benefit the society. So after 20 years, others can use the technology. But till 20 years, you alone have enjoyed your rights, and you have stopped others from making or producing or marketing similar kind of things. That's the thing. That's the reason they have made it on only 20 years. I hope it is clear, right? This is how a patent application looks like. And after grant, they are going to receive the application patent grant, that is a grant certificate which the inventor is going to receive. So patent search, I'm just quickly given view about the patent search, like what is the benefit of conducting the prior art search and how to do it. So to find out whether the similar kind of inventions are already available, and how to claim your inventions. For example, you have come out with 10 claims and you knew it that all the 10 claims were not novel. So you should articulate, and you have to change your invention in such a way, like you should highlight your novel points in the claims. So that thing you can do only after conducting the prior art search. Why? Because drafting of the claims is the major part in the patent filing. And as I said earlier, there are few things which cannot be patented, right? So under section 3 and 4, you can just go through this, like a method of agriculture or an against to natural laws cannot be patented, or a game cannot be patented, literary, dramatic, these all comes under copyright, that cannot be patented. So there are few things which are not copyrighted, which on everything falls under section 3 and 4. And this is one of the free database. It is readily available. You can just simply go to Google Patents. After going through Google Patents, you will be getting this particular screen. You can access it with patents.google.com, and you have to, if you are aware about the patent application number, you can go with that, or else simply you can give the keywords. Simple search. For example, if you're coming out with an wheelchair, let's say. So what are the features of the wheelchair? It's an IoT based. Okay, it is automated, and it has a joystick. What kind of controllers you are using? So these are some of the keywords you will be giving over here, and based upon keywords, you will be getting all the results over there. And then you will get to know like what are the similar inventions available with reference to your inventions. So I am done with the patent part. If you have any doubts, you can ask me. And now we will be proceeding to the industrial design. Okay. So coming to the industrial design, Rao sir has requested me to concentrate more on industrial design. Why? Because you people are we will be doing dealing with similar kind of things, right? You are coming with a lot of new designs, right? So that's the reason I'll be. If you have any doubts in industrial design, please do kindly ask me. So the patent protection rights for the industrial design is for 10 years, and they can be renewed for an additional period of 5 years. That is a timeline. And for what industrial design can be protected? For any shape, configuration, surface, pattern, color. I'll just give you an examples also, like what can be patented and what can be protected as an industrial design. That difference also I can give you. See, basically, when you have done with a product, there'll be a lot of questions in your mind whether to go for a patent or you have to file for an industrial design. That's the basic question you will get it. So you have to note down when you have come with a particular product. If you want to protect the technical features or scientific elements of the particular product, then you should go for a patent. If you want to only protect the outside external look, the features, aesthetic appeal of a particular product, then you have to go for an industrial design. If you want to go with the technical features, then you have to go for a patent. If you want to only file the external appearance or the look, then you have to go for a design. So the patenting criteria, it is very strict, as it has to go through industrial applicability, inventive step has to be there, it has to be novel. So the patentability criteria is strict compared to the industrial design. Industrial design, only they'll go through the outer part shapes, like whether you are infringing with any other similar kind of product or design or not. That's it. Nothing else they will go through it. In depth, they will not evaluate. Okay. And the factors considered is, I have written, right? It has to be original and it should not be similar with the other things. And here you do have these three things. The duration is, the patent is 20 years and the industrial design is for 10 years. And some examples, I'll show you the examples also. And it comes to the cost. The patent is very high, and when it comes to the and the industrial design, the cost is very low, and the governing standard use, the duration for filing is also. I'll quickly run up. So this is the basic one major example I can give you. Here we do have Fanta and Coca-Cola bottles over here. So the formulation, what the Fanta and Coca-Cola does, it is protected under patent. You understand the point? The formulation for preparing the process for preparing the Fanta and Coca-Cola comes under a patent. It doesn't come under industrial design. Whereas the outer external design of the bottle, you can see that there's a difference between the two bottles, right? The design comes under an industrial design. So that is the major basic difference between an industrial design and a patent. And these are some of the examples which I want to explain you. You are aware about this iPhone, right? It is very, very famous for this aesthetic, classy look, right? Everybody wants to have it in your hand, right? So why people are crazy about iPhone? Just because of it aesthetic look, right? It's look very classy compared to the other phones. So that is then competitive edge which the Apple have. Okay. So he had a lot of protections for industrial design. And also that is one of the foldable bicycle, which is a very famous, and the workspace, which we are following right now. And another one is a moving chair. And the last one is a lamp, which are some of the unique designs. And so as I have explained, I'll just skip these things. Yeah. Items cannot be registered. I have mentioned over here, the books, jackets, labels, tokens. These all comes under copyright, not under industrial design. What are the advantages? Just like similar to the patents only, we do have some design classes. So these are the application procedure, similar to the patent only. Initially, we'll be having the filing, and then it will come to the examination. And then if there are any opposition or objections, it will go to the hearing stage. If there are no objections, it will go to the whether it will be granted or it will be refused. Okay. So how to conduct an IP search? I'll just give you a quick thing. ipindia.gov.in, you can just go through it, and you have to here mention please enter the text. You can just simply mention over there what kind of product do you have. For example, if you have come out with an new earphones design. Okay, you can simply give it over there, like earphones, Bluetooth earphones, whatever it can be. You can just give it over there, and you can get to know like what are the other competitor available products available in that particular sector. This is some of the examples which I am showing here. While just a second, sir. While you are you are going for an industrial design, you have to show all the perspective views. For example, here the black paper thresher cum grader. See, he has given the left side view, the back top view, next front view, side view, everything, all the perspective 360 degrees views one has to submit to the patent office. Irrespective of your product, whatever you are submitting to the patent office, the final photographs, that only will be considered, and for that particular copies only you will be getting the grant. So whatever you are submitting finally, the perspective views you are submitting to the in the patent office, for those things only you will be getting the protection. This is the one another which we have filed, that is multi-purpose dishwasher and cloth washer, a combination of. And coming to copyright, I'll just quickly end it up here. So copyright is like what can be copyrighted is example books, paintings, films. These all can be copyrighted. For example, you come out with new drawings, right? You come out with new architects, new design. Those all can be copyrighted. If you have any photographs with you, if you have any drawings with you, those can be copyrighted. And for copyright, you do have 60 years of lifetime. These are some of the literary works. And I just want to mention one more thing. Since we are in the digital era, nowadays there is a rise in the copyright applications. Why? Because now there are a lot of new web applications, mobile applications, software, games coming up, right? These all come under copyright application. The web applications, whatever you are under every website, you will see, right? Copyrighted at the rate of 2021-22. So every application, every software, every game, those all comes under copyright applications. Trademarks. So trademarks is like you, for example, if you want to create a brand, then you have to protect your logo, or you have to come out with an your brand name or your company name. You have to register it. That is what a trademark is given for. Why? Because why the trademark is needed? Why? Because somebody has to identify your business, right? There are n number of businesses happening present everywhere, but how do you differentiate yourself from the other people? So you have to create your brand. For example, we all know like we do have well-known brands, right? We do have Tata, and we do have Fast Track, we do have Nike. We all prefer those brands over other brands, right? Why? They have created a particular brand value. In order to create that brand value, you have to come out with your trademark registrations. You have to register your marks. Okay, it can be a logo, it can be a mark. Service also can be there. Yes, yes. Copyrighted. Yes. Title, they will block it, and yes, logos can be blocked, ma'am. Actually, in fact, an individual can register their logo. Then no need to be an organization. For example, you are there in my name. I can just register logo and I can use it later on. We can do that. But trademark will be granted only as a single individual person. For example, if you are a group of 3 people and you want to register your name, that is not possible. Only for an organization or for an individual. There are only 2 options available. These are the different kinds of marks which we have for trademark. Like it must be unique. See, while you have pending applications, wherever you find it as TM, that means the application is not yet registered. The application is still in the stage of pending. Then you will find the mark as TM. If it is R, the R symbol is there, right? If it is mentioned as R, then it is a registered mark. That's the difference between the TM and the R. Everywhere in your day-to-day activities, you will find out these marks everywhere in most of the products. That's the major difference between the TM and the R. Yes, sir. Simple, sir. We cannot judge when it is a TM. Why? Because you don't know when they have actually registered it. It might be just before 1 month he has applied for an application, or before 3 months he has applied for it. But since there is an opposition and there is similar kind of trademark, that's the reason the trademark is not issued to him. So actually, R against his name. No, ma'am. Just to differentiate, they have kept it. It doesn't define your complete product. Quality of the product. Obviously not. It's just your brand image value, that's it. Yes, sir. Yes, sir. No, no, no. Within a span of 6 months only, it will be translated from TM to R. Yeah, ma'am. Once you get an R, again it is valid. It is valid for 10 years after getting R. Ma'am, copyright is a different thing. Trade, you know that trademark patent is not so easy, ma'am. We do have a lot of guidelines for it. Patent Act, it's like an whole 300 400 page book we have for the Patent Act, right? So it's not so easy. I'm done, sir. Just a second. One second.
Any questions from the audience?
So these are the different classes. Yes, sir. I'm just done with it. If you want to connect this trademark search, again, you can visit the IP India website and you can just give your name or your mark over there. You have to give one class and you have to conduct the search. This is one example which I want to show you. This is one product which we have applied. We have applied for a patent, we have applied for a trademark, and we have applied for the design for a single product. It's an electric vehicle. It's an cargo vehicle. So they do have an own own manufacturing production capability for their battery capacity, and they do have their own circuit. So for that we have patented, and for the design we have done the industrial design, and for the trademark, for the brand name, we have given that. This is one of the example. For a single product, you can go for an multiple different kinds of IP. This is one of the example I just want to show you, and I'm done. So once you are done with your innovation, you should also concentrate on the commercialization part also. You can, if you are not doing on it your own, you can approach NRDC for that, and we will help you for that, for licensing of your IP or for taking your technology into the market. We are there to help you. Yes, I'm done with my presentation. Products, ma'am. Yes, ma'am. But for that, we do assign your technologies. There'll be an agreement between you and us. Through an agreement, we will do that. It's a procedure. Yes. Yes.
Wanted to apply for global level.
Level.
You wanted to apply
You
for
can-
PCT application.
Yeah.
Then what is the best way to conduct research?
Patent scope, you can go through it.
Patent scope.
eSpaceNet, patent scope, European SpaceNet,
eSpaceNet.
or patent scope you can go through.
Yeah.
I'll
okay.
just,
Yeah. One more question. Like before going for commercialization, we have to wait. Like suppose I have applied for a patent, I have to wait for around 18 months to get the patent. Then only I can go for commercialization, right? I have to wait for that.
it's better
It's
to
better
go
to
af-
wait for that.
wait for that publication, but
yeah.
that's the reason. If you are in a hurry, you can go for an expedited and you can get published within a span of 2 months, and then you can go for commercialization. That's the best way I can say. Yeah. Yeah. We do provide facilitations for copyrights for different applications, right?
Thank you. Understand, I think. Any questions? Any questions, sir? Madam, ఇక్కడ రండి.
So for example, we do have Bits Pilani, right? We do have Bits Pilani. They do have some brand image and brand value all over the country, and we do have now in Dubai also, right? Ipudu Bits Pilani, if they have kept it somewhere else, then you can easily identify whether it is like from the owner organization. I mean, from the first organization, or somebody third party has come up with a new organization taking his name. That you have to find out. By what you will find out? By seeing his logo, right? He cannot use his logo like that, right? If it who has not registered, Bits Pilani will have his registration for sure, sir. Why? Because he has a global presence. It's a top institute in India. Then you can approach NRDC, please. Yes, you should approach NRDC for that, and we will. Yeah, we do have it. You can go to IP India and you can simply see NRDC. It's registered. And we have registered for many things actually. Whatever events we do conduct also, we do take trademarks for it. For example, we do have Avishkar magazine. We do have Invention Intelligence. For those things also, we do have trademarks. Okay. Indication. Once, if I'll find time, definitely I'll try to.
So we will have a discussion session in the 4 o'clock at. We will discuss all the things, right? And now, next presentation, Mr. Subhajit Saha. You connected? Is already connected? Okay.
Yeah, am I audible?
Yeah. Good afternoon, sir. Before your presentation, I am just giving brief about you. Mr. Subhajit Saha, Head Legal and IPR, Resolute Group and Resolute for IP. Basically, he is currently working with the Resolute Group and their head of legal IPR. He is also a founder of the brand Resolute for IP, and an IP services arm to Resolute form an objective group of available IP services to all. Prior to that, he has worked as a director and head of CII at Hyderabad. After serving for 17 years, he has been joined to corporate world. He is a postgraduate in microbiology with PG diploma in patent laws from Nalsar. He has completed PG diploma in and project management from University of Hyderabad. Mr. Saha is registered patent and trademark agent with the Indian Patent Office, along with a master's in LLB IPR from Osmania University. His title is IP Management for Academia with a focus on patents and design and copyrights. Thank you, sir. Now we can proceed for the presentation, sir.
Yeah, am I audible to the audience, Dr. Rao? Hello? Yeah, am I audible, please? Yeah, am I audible, sir? I would request if somebody can raise their hands if I am audible.
Yes, sir, it's audible, sir, audible. You please
Yeah,
proceed.
okay. Okay, thank you so much. So, good afternoon to all of you. My name is Subhajit Saha, and today I'm actually presenting something about patents, designs, and copyrights. I think my previous speaker had touched upon the various facets of patents, trademarks, copyrights, and designs. So I would not go much deep into it because some might be overlapping. So I would try to answer more questions rather than and make it more interactive. So one of the questions which I was listening was only we need to commercialize after publication. That's a misnomer, please. The day you file your patent application, it is nothing to do with publication for your commercialization. If you are planning, if you have a good idea, if you have a good technology and know-how, you can look for a licensor and inform that you have filed a patent, and the discussions can begin to look for potential licensees, irrespective of your patent is published or not. Of course, if it is published, it is a one step ahead, and then it is a grant. Definitely, the patent will have more royalties and the licensing fees and all negotiation will be better. But you know that a technology is good to get granted. That's the reason you file a patent. So discussions can start from the day you file the patent. You did not wait till the grant, because sometimes the grant takes 2 years, 3 years. Sometimes it takes even faster. 1 year now it's expedited examination. So that is one I wanted to clarify as a patent and practitioner for the last 22 years. So today's I represent a group called the Resolute Group, which is one of the leading electronic manufacturing service company in India. And these are our brands: Resolute, Radiant, B2B, Rock Salt, and Resolute for IP. So we are one of the largest television manufacturers in India from Telangana in terms of volumes. We have produced 7 million TVs for Samsung, OnePlus, MI, Xiaomi, Coco, Meds, and various brands. So that is what we are. So if you see, you all are surrounded by the world of IP. If you look around, the device which you're carrying, the word which the bags, the backpack, the music which you listen, the Spotify or any kind of music or whatever it is there, you are surrounded by IP all over. You are from the architectural college, so definitely buildings are not under the purview of designs. Please understand, any architectural designs pertaining to buildings which you make, civil structures, are not subject for any patent, trademark, copyright designs. Yes, trademark, of course, now the government is looking at registering trademarks for buildings like the Empire State Building, the Indian Stock Exchange, and Taj Mahal Hotel. They have filed trademarks for the buildings too, provided it is very unique, it has a very good repute, it is very nice and very well known and has trans-border reputation. Then you can go for such trademarks. Again, it is discretion of the society, the registrar, to give this trademark to all of you, to the applicant. So introduction, I think, as I will not go much. IP, everybody understands it's only to do with patents, trademarks, copyrights, designs, but there are many types of IP like semiconductor, plant varieties, GIs, trade secrets, and also copyrights. So it's still understood well, but still I would say needs a lot of deep dive to understand what strategy fits in all, because one size will not fit all. So you need to understand. So IP is nothing but the creation of mind, and it covers a vast range of activity which is scientific, artistic, literary, and various types. So when you have the creation of the mind, you come out with a new idea. Any idea has to be put into practice. Just a vague idea will not help you to understand that yes, you have not a vague idea will not help you to just file a patent. You have to reduce it into a practice, either in the form of a technology solution. So patent is a technology solution to a technological problem. So that is what you need to prove to the patent office with the proof of concept. And the three cardinal rules for getting a patent is, as you know, it has to be novel, it has to have an industrial application, and it has to have a inventive step. So that is the most important part which you need to understand, and you need to prove that. So IP for academia, a thought or a plan or a suggestion for a problem comes, then you work on that. Just like how you join for your PhD, you do a lot of thesis search to understand the white space, understand the research area where you want to work. Your guide will give you 6 months time to identify the problem and come out with your solution, and that solution will be your research subject for the next 5 years or 4 years, where you need to publish papers or any kind of technological progress. So now the focus is that every PhD should translate to at least 1 patent or 2 patents. Then the number of patents will really increase. If you see, ma'am also had mentioned in the earlier slide, 42,000 patents have been granted in the last 22-23 from 4,000 patents every year. Now the target is to grant 1 lakh patents by 2025. So, and also if you see, we have filed more than 50% patents are filed by domestic applicants, which means Indian applicants are filing compared to MNCs. In those days, our filing was only 10%. Today we are 50%. So half of the patents that are filed in the Indian Patent Office are by individuals, by companies, MSMEs, startups, entrepreneurs, academicians based in India, doing innovation in India and filing in India. So that is very important. So the problem, the exploration of the to create the idea, select the best idea, build the test idea, and build and test the idea and evaluate the results. That is how you research your thing. So look around right now. If you see, why does IP matter? Why does IP matter to you? Why do you are having a session today? Dr. Rao has taken the pain to organize this session for you all to understand why is the need. So I was in FDDI a few months back, the Footwear Design and Development Institute, under the Ministry of Industries and Commerce. So they were publishing a lot of their shoes or cloth or other designs and putting it on Facebook, Instagram, and other platforms. And designers used to pick them up and then use them for commercialization. So the students were losing out. So immediately after an IP session, an IP training and capacity building sessions, they have understood the importance. So now they have around 3 designs which are filed, and 1 design, how idea comes. So this is just to give you a brief. It's nothing to do with rocket science or only people with big R&D labs. Or African hornbill is a bird in Africa. So taking that idea of African hornbill, a footwear is designed on the shape of an African hornbill. And the same footwear, the shoes, has been now a design patent. That is industrial design. In the US, you call it design patent. And then it has been now looked for commercialization for any shoemaker to take it up with a brand. So that is how you need to understand. And then IP gives you a return on investment on your creativity, on your knowledge, on your intellectual assets. So it gives you the moolah, it gives you the collaboration platform to work together, to compete, to be in the market. And then, in earlier days, it was very, if you see the map on the left side, the picture, the big sharks used to eat the small fish, and the small fish used to eat the even smaller fish. But today, even a small fish can eat a big fish, because if you have one technology or one platform or one patent, which is enough to give you the revenue or create a first mover advantage in the market and take the market lead, it will be a great service to the patent of the patent to leverage it, and it will be a great service for that company. And with one patent, he can actually start his own company, license it, make for production. That's how all these companies which started, like Google or Facebook or Apple, all these are garage companies. They didn't have any capital, labor, or land, correct? They had only one idea, one innovation, one technology, one platform. That's how Infosys started. That's how TCS TCS has graduated, but Infosys in 1981, with just a meager amount of 10,000, they started the company based on software programming and giving new solutions and understanding that yes, there is this advantage of knowledge economy which will be booming. So if you look at today, the world is based on knowledge economy. Intangible assets have overpowered tangible assets. 90% of the world is looking at intangible assets. When you want to do a merger or acquisition by any company, they do not look at the assets. Physical assets are only 10% with depreciation. The 90% balance assets will be your share value, your technical know-how, your trade secrets, your patents, your copyrights, your designs, your all the IPs, your brands. So if you look at these for decades, neither promotion nor protection slowly was evolving. IP was not in the teaching curriculum. It was never in the teaching curriculum. People used to just file and forget. They were most of them, even I would say today, they are most filing it for biodata patents. If we work with a lot of colleges here, but nothing has been moving in terms of whether you realize what is the ideology, purpose, or the what is the major aim of this, to understand why you want to file a patent. First question has to be whether you want to commercialize it, or you want to get name, or you want to get money, you want to get fame, or what is it. So that should be the first ideology of any institution, any entrepreneur, basically, and then take. So things were not that smooth on IP till 2016. We used to get a patent grant in 10 years. We used to get a trademark grant in 4 years. We used to get a design grant in 2 years. After 2016, slowly the national IP policy, things have streamlined well. I think now a patent is granted within, average time is around 3 years in India, 3 to 4 years. If you go in a smooth sailing case, that still it is less, very much greater than the US, where it is 2 years, and China, which is 1.5, 2 years. So still we are double the time, but if you expedite it, you can get it in 2, 3 years. But the average time taking for a patent grant in a smooth sailing case in India is 4 years still. Trademark, I think we got it granted in 6 months, because the 4-month statutory publication is there. After the trademark is accepted for publication. Designs, again 6 months you get a grant. As ma'am was mentioning, it was one of the most cheapest and the fastest form of IP to be granted in India right now. And copyright, again, it takes 8 to 10 months to get it registered and granted. So these are some of the things. So why do you need to learn about IPR? It is your right. It gives you the Medavu Hakkulu. It is called, so it is the IP rights. Medo Sampatti Hakkulu, which means in Telugu, it is your intellectual property right, which comes from that your labor. And the creation and protection of this right is important, and its enforcement. So when you want to use this, so IP has become a buzzword in almost any career. So there are a lot of lucrative opportunities for academia to venture into. So what is IPR? A classic real estate analogy. Just like you ideate, protect, manage, and monetize, the same way you can gift IP, you can transfer an IP, abandon an IP, license an IP, authorize an IP. So that is how you do. So except GI, all IPs can be assigned. GI cannot be assigned because it's a community right. It's not an individual right, unlike other IPs. All IP rights are territorial. As I was saying, if a particular IP right is there in one country, it can be enforced in that country only. Then if you do not have an IP in other country, anybody is free to make, use, sell, or import that invention, and you cannot do anything enforcement. But that he will not get a patent for it, but he is free to use it, sell it, make it, or do whatever. So IP, all IP rights are territorial, except copyright. When you have a copyright, like a J.K. Rowling book for Harry Potter, you cannot just copy here and start selling copies. But because as per the Berne Convention of the copyrights, if a copyright is registered in that home country, and if we are a member of Berne Convention, automatically when the author or the writer comes to India with the publication, the country is the host country has to reciprocate by granting a copyright in the same country, irrespective of whether it is filed in the copyright office or not, and it gets a likewise of protection. So when authors go abroad, they also enjoy this kind of cross Berne Convention rights, where automatically rights are granted to copyright authors. So patent, I will not go in detail. You all are aware. So what are the advantages? Also, it helps in prevent copying. Disadvantages. So what can be patented? It can be a product, a composition, an apparatus, a process, or an improvement. So I will give you an example. We had a patent for an ambidextrous drafting design. So drafting device. So an engineering student who was left-hander had an issue in drafting in using his drafter, because so he had made a drafter which is ambidextrous, which can be used by both right hand people and left hand people, and he added some instruments like protractor, compass, everything on that as a holder on it. So it's a one-stop shop for you, so that you don't have to buy. Earlier a drafter used to be bought, and then a compass box and other accessories. So he has made a drafter with the accessories and also a provision where both the right hand is lefties and righties can use it nicely. So he got a design patent for it granted functionally, because and for the patent is still under consideration with some claims which we are working out. That is how you should understand. Then bidirectional grinding of a mixie, the blade. The same technology was used by a farmer in making a rotary plow. So what he has done is he's using a plow which is rotating in twice. It is digging as well as it is throwing up the soil. So it is churning the soil as well as it is throwing up the soil on the other side. So far, you are making the field ready for sowing. So the same thing was fixed in this tractor. It is called a rotary plow, detachable rotary plow to be fixed in tractors. So that is how he has done it, and that is how it is very important to understand. If you see, 90% of the inventions of patents are for the improvements of existing innovations, which means that you do not have a eureka moment every time. Eureka moment comes once in 20 years or 30 years, like that. But if you want to understand that, yes, only improvements, mere improvements or some kind of additional improvements, you will be able to understand that these are filed for patent filing. So find the three improvements in this. I think this is a latch. It is a rat trap. It was used, and then if you see the rat trap, the cheese like smell, plastic smell, and spring is longer, hook on the end of the arm. So this was used for catching the rat trap, a mice trap device. So in 1976, in 50 years, that was one of the patents which were granted at that time, and this was for again after 50 years. So that is what abstract ideas discovery section 3 of the Patent Act discuss you from all these inventions not to be granted. How does one get a patent? I will not go again. I think ma'am has filed. So this is what the ma'am has already discussed. Sorry. First Indian patent was an efficient pumpa pulling machine. This is George Canning was there, who was the first in 1850s. And then Apple holds 1,000 patents relating to iPhone and voice control, camera function, and now it is mainly for wireless charging and all that. So definitely one product will have multiple IPs as ma'am was mentioning, but also there is something concept called as open innovation or free knowledge, where you will actually note that you will not be able to understand that, yes, you will that this is very important. Some inventions can be filed for a patent or some can be given free to everybody. So like the WW, the World Wide Web, the matches, the karaoke, all these were inventions, but they were all given for free without any royalty or licensing fee. Post-it, an industrial glue which was supposed to be made, was very less in glue, but then it was converted into an invention, Post-it for notes, and then it was used. Industrial design, again, I will not go into detail, ma'am has already explained. You just have to understand industrial design protects functionality, aesthetics, whereas patent protects technicality and the working mechanism. So anything which lures the eye of a customer to buy a product, you will be able to understand that. So copyright, again, original ideas, creative expression, they protect rights of copyright holder, distribution, public performance, translation, adaptation, some of the original copyright works, and these are some of the creative industries which you want to have. So this is very important. Before I end, I will want to spend at least 5 minutes for all of you. I'm not sure how much is the strength. I see that the turnover is a little less in the class, but it's okay. As well, the spirit and the interest is intact. The turnover doesn't matter. Whether it is if one of you learn today and spread this IP knowledge to 10 people, and another one will spread to other as a multiplier effect. I'm sure that 100 students will learn on IP, though you have 10 or 15 people who are there in the hall. So that is what I wanted to communicate. Strength is nothing to do with knowledge. Knowledge can be given to one or it can be given to 100. The way of the mode is very important. So authorship does not equal inventorship. So this is the major thing. When you publish a paper, you have inventors, authors who publish, whereas in patent you have something called as inventors. So if a person is saying I am the first author in patent, there is nothing called as first inventor or second inventor. All the inventors have equal rights. All the inventors have the equal share in the patent, unlike the value for the first author or the second or third author. So here is an example from electricity from garbage. Eric, a professor working in his laboratory, invented a machine that produced electricity from garbage. He recorded all his efforts in laboratory book. The invention was incredible. It produced cheap energy. It released no pollutants, and it reduced the amount of garbage. It reduced the amount. So, however, it had a problem. It did not work for more than 1 minute at a time. So Eric could not solve this problem. Sophie, a graduate student in Eric's group, thought of a way to solve the problem. So many things needed to be done to apply Sophie's idea. Eric's department chair, Mark, was asked to provide support dollars to conduct the research. Eric sent Chris to an undergraduate student assistant to get all the equipment. Finally, after 2 months and many hours of work, Eric, Sophie, and Chris, the garbage machine was creating electricity for hours at a time. All the work they did was recorded in Eric's laboratory notebook. Sophie also kept a separate notebook of her research activities and contribution. Chris provided data for both Eric and Sophie. The improved invention was a success. The scientific world was amazed. The university is now telling Eric the invention is worth millions and it will patent the invention. Eric's university has a patent policy similar to McGill's. Publication describing the invention is co-authored by Sophie. Are they all inventors? Who will receive the millions? So these are your questions, and this you need to understand. If you have an IP policy, I'm not sure if your university has an IP policy. If it has, well and good. You need to revisit. Always keep it dynamic, evolve with time. Have a way where you can get more ideas because things change. Technology is always ahead of law, so you need to understand that you need to catch up. So IP policy which is there, please revisit every year or at least once in 2 years to see. If I've seen many organizations having IP policy but not defining it properly. The scope is not there. People are left out. They don't understand. With changing time, now you have deep fakes coming in. Now you have machine versus man. You have AIs. So who will own the invention? What is the amount of work to be done? Who is doing the ownership issues, attributes? All these are very important questions. So what is an intellectual contribution then in this case? An inventor enables an idea, or who worked? Mark, Eric, Sophie, and Chris all contributed to reduce the invention into practice, but they are not all inventors. You need to understand who thinks that a student to be an inventor or co-inventor. Co-inventor has rights. So how are Mark, Sophie, and Chris described? So this is what you have to understand. What if there is an inventorship dispute? Each person must provide documents explaining and finally resolve the matter. So documentation is the key. Please understand that when you are in your college, when you are going, documentation is the key. You want to understand that yes, you have to keep your records, your working instruments, and all the work documented properly, so that tomorrow when you're going to any kind of debate, court of law, you are clean and clear. So this is what is your thing: one IP, many IP rights; one product, many IP rights. So this is one again important slide. If you are working on any contract research, you should be aware that there might be patents, know-how, copyright, design rights, and database rights. Industrial design projects, again, all these developing software, then you should see whether it can be patentable. It can be know-how, because software per se is not patentable in India. It is a copyright subject matter. All your algorithms, all your programming languages, open source and object code and open source will all are thing. But anything related to computer related inventions where a software is embedded in a hardware giving a technical effect, if you can show and prove that, that can be patentable. So these are some of the slides which will help you. Factors which may be used to determine who owns the IP. Are you a member of the staff? Are you a student? What type of IP you have created? How and with whom did you create? Where did you create the IP? All these questions must be answered, agreed, and then articulated to come out with the roadmap. So then only you will understand and when to start protecting your creative work before making it public. Understand which IP rights do you need. Need investors looking for partnership as soon as possible. The first to file wins. So casual attitude, not filing a provisional, failing to create an IP plan, not setting and confidentiality agreements, failing to run trademark searches, IP searches, design searches will give it into you will enter into a whirlwind of competing with others and wasting your time, efforts, and money. So key takeaways for everybody: identify your IP, record it, protect it, value it, commercialize, attribute ownership, enforce, and have a strong policy. If you think it, protect it, because if it's worth copying, it is worth protecting. I think with this I will end, and I hope this session was useful. I am open to any questions or any kind of doubts which you have. You can shoot at me and I can answer those. Thank you so much, Dr. Rao, for this wonderful opportunity. Thank you.
Thank you, sir. Wonderful presentation. And any questions from the audience? Any questions? No questions. Madam, you have any questions? Sir? Ask, ma'am. He will give you the clear answer. Yeah. Yes, yes. Okay, PPT you need, right? Sir, I think they are asking your PPT. It can be.
Yeah, it can be shared.
Okay.
It can be shared. Though there is
Okay. Okay.
unless and until they don't commercialize it, they can use it.
They will not commercialize it. They want to know.
There's nothing to commercialize. Just on a lighter note.
Only for academic and research purpose.
Yeah, that is the disclaimer everybody gives. Need to define. Yeah. Any questions? I'll be more than happy to answer any doubts.
Hello, sir.
Yeah.
Sir, I have a question. What is the maximum number of inventor any innovation can have? Is there any limit to that?
It's a good question. Actually, there is no limit such in the Act. The Patents Act 1970 does not state anything on the number of inventors. But basically, I have seen colleges want to name 17 students, 18 students. That's why I said you need to understand who has contributed what for the invention. If there's a genuine contribution, please name them. Just for the sake of naming, it doesn't make sense, because tomorrow if you're getting it commercialized, then you have to actually give the licensing fee, put a lot of agreements, and once you name them, it's fine. But the applicant is the main owner, legal owner of the patent. But once you name them, you cannot remove them, and you cannot add any inventors or delete inventors unless and until there is a special provision on petition. Because we have to be very careful that somebody comes tomorrow and says, I have not been named, and files a suit or something like that. Then you need to. So it's always better to first get a clarity. There is something called as declaration of inventorship in the form 5 of the Patents Act, where the patents will give the NOC to the applicant. Your voice is breaking. I'm not able to hear you. Yeah.
Yes, all the inventors are equal value. Applicants mean?
Sir, can you translate that? Can you ask me that question again?
You asked, you tell me that all inventors are equally shared or not?
All inventors, you told that all inventors have equal share. Yeah, but there is one person who is applying for that innovation. So what is the extra benefit, or is there any benefit which the applicants have?
No, all inventors will not see. What I meant is, when you talk about applicant, there will be 4 or 5 applicants in a patent application. In the US, it's called assignee. So they will have equal rights in the patent. Inventors are only acknowledged and named. They will not have any rights to license, commercialize, or talk with any third party. That's the duty of the applicant. Okay, with who is the owner? Okay, the inventor is only named, acknowledged, given acknowledged for his work done. And why? Because tomorrow, if you see movies like 3 Idiots and all, where you have because people in the West and worldwide search with inventors search. They want to see inventors who have done research in nanotechnology, in diabetes, or some kind of new technologies. They will go with the inventor search and they'll get them to their companies. So that is the reason recognition people want to be named as inventors. They do not have any rights in the patent, okay, except being named as an inventor. The applicant is the sole owner of the patent, and internally they will have an agreement that yes, if I get this patent commercialized or I get this done, then I will give some royalty share of 70-30%. That generally colleges have 70-30. 70% go to the university and 30% goes to the inventors.
Can there be 2 applicants or 3 applicants?
Of course, there can be many applicants, 4 or 5. There is no again limit to that.
Okay. That's all. Thank you, sir.
Thank you.
You heard about honorary authorships. Some people, see, for example, a teacher or students, mutually they are writing some papers. For example, if you see science,
You see the nature journals. Their number of papers, their number of authors will be there, but really they are contributing with the content. Whereas some namesake means honorary authors here, without contribution, they are keeping some other names for the recognition. That is, should not be there. So while talking about the inventions, let's see, it's its own creativity, right? You should be get a credit for it. So that's why you should be minimize your share. It's a economic viability. It's your own credit. So it should not be said for you many people. But that's something. It's your research and your creativity should be it's you. That should not be shared with much people. Too many authors are not at all good. When you talk about research, it means thesis in point of thesis. Obviously, it will go to the institute or no, it credit also at the same time student also getting. So any questions? Sir, sir, once again, question. हाँ मैं बता रहा हूँ. Sir, can you explain about the trade secret? Trade secret, and can we apply for that? And what will be the procedure for applying a trade secret?
Okay, see, trade secret is a form of intellectual property right, but you do not have any statutory obligations to register. There is no such office or form or any kind of a controlled mechanism or regulatory thing for trade secrets. Okay, a trade secret is a trade secret which is having high commercial value, and you have taken due steps to protect it and keep it safe from others only on need to know basis or with your management. And also it is having a value of certain things. It can be a formula, it can be a formulation, it can be any kind of your, like I'll give you an example. If you want to launch a product today in 500 cities, so you have 500 dealers where you can launch your product in one go, whereas your competitor has only 10 or 15 dealers in other cities. He is not able to do. So your competent list of 500 dealers where you can launch your product in one go is your trade secret. You don't want to publish it, you don't want to protect it, you don't want to keep it anywhere. How do you protect it? You keep it secret. So as long as you are keeping it secret from others and you are taken steps and you own it, it is just a form of IP, but it does not have any legal binding on to have a, like the Patent Act is there, the Trademark Act is there, the office is there. So there's no such regulation on trade secret where you can register. Okay, it's an IP which you keep it to yourself to leverage for business competence. The Coke formulation, the KFC or the Batini Goats family in giving that fish medicine in Hyderabad is a trade secret, but he has not commercialized it. So it is your choice. But the disadvantage of trade secret is that once it gets leaked, okay, once it is in the market, then you cannot take any enforcement right because you have not got any protection. So you have to be very careful and keep it close to your chest and see that nobody copies it. In case there is a spillover, you have some kind of statutes like the Contracts Act, the Law of Torts, and like agreements like confidentiality, non-disclosure, and criminal, the IPC, where you can sue the other party on various cheating, fraud, and some kind of data theft and all under the IT Act and all 65 thing where you can do. But there is no such proper standard trade secret registration portal, or I would say a regulation authority to give you a trade secret registration. Yes, in the US also there is no such thing. Trade secrets are not protected, registered anywhere. They are self-regulated by the organization and they take due steps to keep it intact for their business competence. And yes, US has a law, it's called the Uniform Trade Secrets Act, which helps in defining trade secrets, the punishments given for trade secrets, the just like an act. So we are also trying to work with the Parliament is working on it, on both the data protection bill as well as this Trade Secrets Act. sooner than later we will have to have a Trade Secrets Act in India to protect, because a lot of MSMEs suffer, and also a lot of other people suffer, because enforcement of trade secret is really tough, because you don't have anything. It's just in the air. How you prove it in the court of law? How you take ownership? Have you stolen anything? How do you tell it? You have to prove. The burden of proof lies. So it's very tough to enforce trade secret. But you need to protect it well, and as long as you protect it, it is a gold mine for you. Thank you.
Madam, one more question.
Hello, sir, I have one question. When we apply for patent, is there any advantage or disadvantage of applying as through the institution, with the institution address or tag or something like that?
See, earlier, earlier, as you know, the amendment which happened, institutions were 8,000 rupees was the fee. Now even institutions are having the same fee of 1,600 as a individual. So individual startups and have the same fees, MSMEs. So it doesn't make any difference. The only thing is that if you don't put your institution name, it will not figure out in the overall ranking of patent in your patent office annual report. So if you see now, who are the last lovely professional university, Amity University, CSIR, and other universities have topped, and you don't IITs collectively they are topping. So if you start filing individual names, they'll not figure out. Your institution will never figure out in that list. So earlier people used to do, when I was in Chennai, I remembered, I'll just give you this small example. What they used to do is they used to file in the name of an individual first, so that it is 1,600 rupees, and then they used to also go for a PCT filing in individual name only, so that the costs are almost 1/4. This was when I was talking about 2 years back, when the cost was 4x for academic institutions. Now when they look for, after the patent is filed, published with a good examination report and a good commercial edge, and they thought they got good licensees, then they commercialize the invention. Now when at the time of commercialization, they had done an assignment from the inventor to the university. Okay, because now they have got, yes, there is a market. There was an internal agreement between the professor and the university that once it commercialized, I will transfer it to my university. But you have to pay the fees of university from filing as a retrospective. But now they are sure that yes, we have revenue. Otherwise, if they don't have revenue, they lost only say 25 rupees instead of 100 rupees. You are understanding what I'm trying to say? Because once they got a licensee, they know that they are assigning, then they assign it to the university takes over. Because tomorrow, if there is a litigation, if there is a problem, as an individual, as a professor, you will not be able to fight your own case. You need a battery of lawyers or some technocrats who will help you and all that. So it's always better to transfer it to the university, as long as you're okay and your policy says that.
In addition to that, ma'am, actually it's two things we need to know. Actually, individual is individual, and individual plus institution is you are attaching to the institution, means you are availing the institution facilities, and institution, based on the institution only you are getting a research project. Based on that, you have developed the research, and after that you are making some product. After that, you are making some institutional product activities, and after that commercialization. It means if your individual point of view, you can take your name. Plus, if it is not connected to the institution, you can be single author. You can single inventor. Hmm. Hmm. No. Name, you see, you are working with the SPA Vijayawada. The institute, when somebody search information, SPA, Professor Vijay Lakshmi, affiliation, they will see SPA Vijayawada. SPA Vijayawada will get some credit in ranking or whatever recognition globally. After that, it will be across the globe. We will be recognized by the name of SPAV, and you will be getting projects. You will be getting some awards and Nobel prizes like that. So this is the importance of the thing, right? Any questions from the audience, sir? Thank you, sir. Thank you for giving you. One more question. Yeah, please.
Sir, we have a landscape design course in the college. So how can we contribute in the geographical indication?
Sorry. Landscape design is for your landscaping. Geographical indication is totally different. Geographical indication is a form of intellectual property which identifies a particular product from a particular place having certain historical significance and having a characteristic attributes to that product, either agricultural or foodstuff or manufactured or any handicrafts. So that is geographical indication. Okay. Now, if you are talking about landscape architecture, where you have created a beautiful garden or some kind of a nice historic building or something, you maintain a catalog. Go for a copyright. Okay, you go for a copyright. Take a picture of it. Take a maintain a copyright for any artistic literary work which is there. A landscape garden can be an artistic work or a literary work, or not literary, sorry, the artistic work or a visual work, which can be, or a video film. You can make a film of that landscape garden done by your own college and put a title and go for a copyright. But any design, you will not get a design for it. You will not get a patent for it. You will not get a GI for it.
So understand, sir?
Sir, one more question. We are architects, so we usually design the buildings. So many people ask, because I filed a few designs and patents. So many people ask about they have some new type of innovation in the building. So can you explain about the limitations, how the person can apply for a building copyright, or can we change into a design, or what are the criteria of building design to put into the intellectual property right?
See, as long as you have, suppose you're an architect, you have made a particular, amount of, the composition, either a product or a process can be patentable. Okay, now if you have something called as the green materials, whether you are using a paint which is reflecting, anti-heat absorbent, okay, UV absorbent, or those kind of technologies which are applied in the building, whether it can be a glass, it can be any kind of air, the way by which the air is getting purified, where those processes and those things related, where you have found out a technological solution to a problem, is patentable. Mere buildings, whether it is new, like your Trump Tower is very odd in your US, whether it is the Burj Khalifa and all, will not get a design patent for it. Okay, so the technology to build Burj Khalifa, whether it is beams and columns or the prefabricated structures which have now been done, those kind of precastings, or those technologies which are made to make your construction easy and construction faster, those technologies are patented. Okay, but not the per se of a building per se. Okay, anything which are the TMT bars, okay, where you have this composition of your alloys and ores and how it made. Every TMT is, whether it is TMT bars, you have some Radha TMT and all that. So each of them are a trademark, but the ingredient which goes into make that steel harder tensile strength, earthquake proof, or some kind of those technologies are patentable. Please understand. Okay, and designs per se, yes, you can file designs provided there is a very good, where you want to make through an industrial process a multiple products of those. So I can't make multiple buildings, or designs are made for a mouse, where I can make 1 billion mouses from a laptop, or a laptop where consumption designs I can't make. The industrial design, either a 2D or a 3D model. If you want to make a model of a building, okay, that your model of a building, that can go for a design. Your miniature model of Burj Khalifa, if it was filed for a design, it could go for a design. Okay, provided you are selling it to, you have got, it is a new design and all, but the building per se will not. But yes, if you are making a wax model, or you are making a very innovative model of the Burj Khalifa, but now you can't, because already it is in public domain. So you have to have it new, original and novel. So once you publish it, you can't get any design also. Hope I am clear. You understood, sir?
Yes, sir. One more question. We have a technology of 3D printing. If some company comes and they will 3D print the building, so it will be a kind of product for them. So can we apply for patents?
No, no, no. You
3D
can't apply for patents. You can't apply for the 3D
designs.
printing. For design, no, 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 you can't. Because if you want to do, see, there was a recently in Siddipet, a temple was built 2 days back. That a 3D printing first temple in Telangana was built by a 3D printing. Okay. So the 3D printing technology is patentable. But the product coming out from 3D printing is not. Unless and until you are coming out with a new design of 3D printing. Suppose I'm making a shoe, I'm making a shoe or making a bottle from a 3D printer, and that bottle is totally new, like the Coca-Cola bottle or the small Coca-Cola bottle of 200 ml. That's a new design. Then that is design patent. Okay, though you are making from 3D printing or anywhere, it is a patent as long as it is original and has a new shape. But let's say like if you're printing something, you're making a police station or making a hotel tomorrow, those are not patentable, or you won't get IP on them. The 3D technology, the 3D printing is always it's patentable. So that printing technology is already patented long time back.
Sir, actually, architectural drawings or plans comes under the copyright, right?
Yes, you're
Whereas,
right.
whereas your in that copyright, your designs and all, in these designs, it's involving any structural point of view, which can be a patentable. When you so that is when you see the architectural patent, when you type architectural patent in Google, you will get to know all the things, right? Thank you. Any doubts, sir? Any questions from the other side? Thank you, sir. Thank you very much for sparing your valuable time. Thank you very much, sir, despite your busy schedule.
No, thank you so much for this opportunity. I look forward to visit your campus someday, and hope
Yeah,
to
please,
see you
please.
one of the top filers
Yes,
in
sir.
the
Yes,
in the
thank you.
patent office report soon.
Yes, sir. Thank you.
And I would thank my earlier previous speaker also. I know NRDC well, Mr. Sahu also, Dr. Sahu,
Yeah,
who is
BK
there.
Sahu, sir. He
Yeah,
only,
BK
sir.
Sahu. Yeah.
Yeah.
So thank you so much. Take care. Thank you, sir. Thank you, everybody. Bye bye.
Thank you, sir. Good day. We'll have a lunch, sir, in the first floor. to everyone. Now, finally, our chief guest, Dr. Bharat, has arrived here. Give him big round of applause, despite of many troubles. Thank you, sir, for coming all the way from Nagpur. And now we have a presentation of our internal faculty. You all know very well. And Mr. Pushpendra Kumar, he is the first alumni of the institute. Got a job of SPA Vijayawada. Is the first person, and he is the first person for IPR. He got a patent for it. Give him big round of applause from the institute. So now he is going to deliver his lecture on IPR for designers and architects, ideations and development. And now Pushpendra is for you. That's open for you.
Thank you, sir, for the introduction. So today we will see why how architects and designers should proceed in the design, and how can they do innovations and they can apply for the patents or IPR, right? So there are categories in IPR. So you can file the patent, you can apply for the design registration, you can apply for uh, trademark, you can apply for the different things. So accordingly, if you are doing or involved in any type of innovation, then accordingly you can proceed for the IPR. So I will go through some examples, and you will see how you have to convert your work into the innovations, because everybody is doing some assessments in the class. So mostly I try to do from my side. If a student is working on some assessment, I try to convert into the innovation. So little bit efforts of the student, and there will be a my guidance from the other side, so we can generate some type of innovations, and later on there will be a benefit of the faculty as well as the benefit of the student. So both of the side there will be a benefit. So converting your assessment into the innovation is very, very important. And this is design college, like architecture is also part of design. So you will be dealing with the different type of design operations. So there are various departments like architecture department. So you will be dealing some type of problem related to the architecture. There is master sustainable architecture. So you will be dealing some problems with the sustainability. So you will try to improve or to try to achieve the perfection into the sustainability. So these factors, and later on you will see there is uh, other fields like related to the greenery. There is conservation architecture is also there. So where you can do the innovations with the when you get the inspiration from the heritage. So these all things are really well proved in the old time. So how we have to convert into the present time, and how we have to achieve in the modern context. So that process we have to see here. So what happens when I talk about how many people want IPR, how many people want to file the patent. So it will be like everybody will say I have one idea. So even in the hall, everybody has one idea. So if they really want to proceed for the patenting thing and to generate some innovation, there is one process you have to go through that, and then accordingly you can proceed or you can achieve the different product. So it will be eligible for the innovation. So the first point is like when I ask about you, do you have some innovation? Everybody will say, yes, I have one product, I want to patent it. So this is not the correct approach in the design field. This is not the correct approach in industrial designing field for the designers when you design some small product. So what is the difference between the small product what is the difference between the architectural products? So what happens is like there will be a one family you will use throughout the life the same house, right? So there will be a same experience for the whole family. So one product you are making if you consider there is a house. So house is like a one product and the single family is using of 6 members. So it will be like one, and when you design a product, it will go into the field and millions of people will be using the same product at a single time. So that is a difference between a product designer and architect. So they have a approach. Even I appreciate the efforts of the architect. They have a ability to understand the user. They have a ability to design something for the user. But for a larger scale, we have to welcome the thoughts of each and everyone. We have to understand, we have to respect of the thoughts of each and everyone. What happens is like we are living in the society, we just watch the actions of the other people. We notice down the we notice down a lot of things in a day of the people we are interacting with the people. So it's like when you really observe yourself, then you will understand the actual problems, right? So first you have to understand yourself, and there will be a process to understand yourself. Then you can pick the problem and give the solution for it. People are not watching their faces, people are watching other faces and try to find the problem and trying to find the solution. First we have to watch our whole routine, we have to watch our daytime, how we are spending our time. So the first approach will be like find the problem in our life, then try to resolve it, right? So this will be the first approach for designers. So why we design? Everybody will be having a point like why we design. There are so many things like you can so to save the time, technically we will, if we are discussing about something, so this will be like saving time and increasing the efficiency of the objects or surrounding whatever existing in our environment. We can increase the efficiency of the products. Like if you are designing the computer, so because of the design factor, you may be designing the whole shield, like it will reduce the temperature, right? So sometimes you don't want some type of innovation in the circuitry things. You are designing the equipment, you are giving the phase of the equipment. Just like you can see the mic, if some problem you face, you should observe the problem and then you will be the person who can really resolve it. We should not always tell to the people this is the problem, this is the problem. We are the people, we have to design something and it will be the solution for the whole society. We will be changing the life of the whole society when we design something. So it's like we are resolving our life. Then a lot of crores of people, millions of people will find the solution because of our one approach, because we noticed some problem in our life. So the relevance starts with this. So if I am facing a problem, somebody else is also facing the same problem in his daily life, right? So starting when you wake up in the morning, you are picking the toothbrush, right? So if you find a problem in the toothbrush, you resolve it. If you face a problem in the soap, when you, because see, you are architects, so you will be having you have a understanding ability to think in a different direction, but you are working in a architectural field, right? But the observation, everybody has the capability of observation. Even all, every member, like in the faculties, even in the technical department, everybody has a memory to understand the problem at least, right? So till the time we understand the problem, then solution will generate from that moment, right? So yeah, I was talking about the brush. So when we like use the brush in the morning, so we are waking up and what we see in the morning, most of the people just pick the brush and clean the teeth, right? So it happens with the most of the people. So the first thing, we are using the product in the life. So our day, the whole routine is going through the different products. So this will be the first product when you wake up. If your product is not according to your choice and if it's not really fulfilling your all the needs, then your whole day will be like little bit depressed. It happens with the men people. So the thing is, so when you start something with your like choices and some disturbance comes, so it depends on the daytime. So if you are facing a problem in the brush, then resolve it yourself, because you are designers, right? So it's not like you have an idea and you have to go for it. So you try to, because one I'll show you the slides ahead. There are so many examples. So when you see the scenario, just like you can see the picture here, so you can see the actual scenario of the society, right? People are facing. So how many people have a different problem captured in this? Anybody can just speak about. So even if you have right now any idea, we can proceed and we can really patent. It's not a very big deal, right? You are designers, I'm also designer. If you have an idea about and noticing down some problem into the picture, you will be able to resolve it also. So first thing is, first find the problem, right? So you can see this picture. What is the problem in the society now? What type of problem people are facing? To collect the water, right? To collect the water. So you can design a device where people can really transport the. So there are so many innovations happened in the, because this is the one area where people face the problem to collect the water from the water tap, right? This is one problem. Other problem I have seen, this was my personal experience, not from the slide. The another problem was in the rural areas. What happens? Some designers have designed the toilet design, right? So it was like pre-filled water inside the tank, and people can capture the water inside the tank, and then later on they can use. So what was the user experience of it? The villager, they were collecting the water in the tank, and in the night time they had to use. So what happens? All the work done by the women in the houses, like they were not using the toilet, they were still going outside. So many people have inquired, like why their ladies are going outside, the men's are using the toilet. So they told that men are very careless. They use whole water, and the female don't want to really fill the water again and again. So they are going out. So they are not putting much effort. So we have to give the solution. What type of solution should be there? So all the people, those are using the product, should be fulfilled, right? So here the actual agenda is not fulfilling. So that also you can see, right? So first we have to understand the user, then accordingly we have to design the product, the system. And this is, you feel like you are architects, you only design the houses. There are so many equipments inside the house that you can see the fan, you can see the latch design, all the hinges, lot of things are there. It's a parts of the house. Like we can proceed for anything, and those are good observers. They can do innovation. Even the housekeeping staff is cleaning every day. If they have a innovation, some some type of idea about to observe the problem, they also can solve something, right? We are designers, we will get the solution. This is the second picture where you can see the wires are like so many hanging around in the, just in the front of the shops, right? So you will see the problem, but find the problem in a very short way. Like this is a large problem, then you can just point out what can be the solution. If you can be the person who can solve it, then you can design something, right? So it will be on you, how you notice down the problems and how you have to solve the problems. This is also like, okay, so somebody has designed, this is a part like related to architecture, I think. So when you see the things, then you have to observe the things, like how can we resolve it, right? So first notice down the problem, then think of. So this is also a tab. So where even personally I have thought, because I travel a lot from railway stations, I have seen the tap design is not in a perfect way, because people don't really think of how much water you have to use, how much and somebody if people also break the tap, they run away. So people have designed a different type of taps where the water wastage will not be there. So there are different type of designs also came in the market, but the psychology is like that. I mean, I don't want to really discourage the people, but somewhere the psychology is like that. Ki if we are getting something in excess amount, I will use it properly. So the whole 50% should go into my right side. So it happens like, so we don't really care of the public things. So that is our duty. That is a designer's duty, how you have to design the things. When you resolve the problem, then automatically you will do the innovations, and then you can apply and proceed for the patents. So this bus stop you can see the scene where the people and the crowd is standing around, and the bus is not really stopping on the main position where the bus should stand. So even in Vijayawada, my friend Deepak and we used to roam around in Vijayawada. When someday we used to go from this street. So we found like why people are standing there. They don't have any particular place to sit in the near to the bus stop, because bus stop area is very small and people cannot be enter inside, like the crowd will be huge in number, so sometimes people are standing outside. So we also have designed lean on, so I will show you in the next slides. So one type of railing where people can get a minimum support, right, for the back side, so they will not be properly sitting, but they will get some type of support, right? So the innovation happened, and we filed 3 patents from the college side. One already approved, we received the certificate also, and we are still waiting for 2. So the first examination report just came in the last month, so we are working on it, and then accordingly we'll send to IPR office. So the same issue, you can see the shelter is there, the bus shelter is there, but the no sitting, just only few people are sitting and other people are just standing outside to the bus stop. That you can see the scenario. So now I was talking about the problem, right? So there are different type of problems. Is this also a problem? Mosquito is also a problem, right? So many industrialists already have thought about like that we can have a solution of. So they invented a lot of things. You can see all these equipments came into the market. Some products are vanished from the market. Some are available, some are not available, and accordingly we can see which product is really successful and which product is not really successful. Okay, so the first is coil. You can see you just have to burn inside the house, and then accordingly you will see uh, the fumes will spread out in the room, then accordingly the mosquito will go off from the room. The second is the mat. You have to keep on the machine, accordingly it will heat up the mat, and then the fumes will I mean go into the room, accordingly it will, so then it will act like that. The third is also the same procedure, the liquid. The fourth is also liquid. The fifth one is you have to burn the paper, then accordingly you can see the fumes will spread out in the room, and then accordingly all the mosquitoes will go out. So what happened is the second machine was not very successful in the market. Why it was not in the market? Because people of India, they try to kept this mat on the bulb, because bulb is also warming up in the houses, right? So you don't require any extra machinery, you just have to keep there. So it was a failure of the company, because the company is making a huge production. They are doing a production in millions of units, so it depends. It really depends, and it really affect the economy, it really affect the budget of the company. So uh, it's going on, and somewhere people are finding the solution like this. So we have to think like what are the available solutions, and how people will use, why people will use. And sometimes we think, so I was just explaining about, we have a different thoughts, but we have to give some refresh, we have to refresh our thoughts, then only we can proceed for the design or the patents, and we can really work into the direction. Sometimes what happens is like we are working on an idea, and what happens is we love our ideas, we really love our ideas. So my design faculty also used to tell in the industrial design course, never love your idea, because if we love, we don't want to leave, right? So we always defend the side. If I am loving my idea, then if you are giving some critic, then I will not really correct, because I always defend my idea. So never love the idea, try and try and try to develop the idea. So that is should be the approach of. So when you love your idea, so this type of designs happens in the field. You can see when you love your idea, so this type of blunders happens in the field. Okay, so it will be aesthetic. You will be putting basically you also can file the patent on these things, but no use. So people will curse the company people. They will not really appreciate the company people. You can see all these ideas. Is it really? So there is a designer who always work to design the bad designs. He always think for the bad designs. So people should understand ki what is bad. So I should not design like that. Even in my class, one student have done the sheet. I told him just to frame it so people will not do this type of work again and keep in the class. So just like that, you people also have to understand. So what is bad idea, and we have to discourage if we are doing bad, and we have to talk to people when we design something. It's not like somebody is stealing. You know, it's a. I think many people heard the name of Shneur Grover, right? He comes into the Shark Tank, right? He used to think मतलब he used to speak about ideas हर चौक पे मिलते हैं. He was talking about like at every signal you will find idea. Even everybody will give you idea. But how to proceed, how to nourish, how to incubate like a child. You have to grow the idea. You have to give the protection to the idea. You have to give, you have to nourish it. You have to talk to people. You have to really talk to people because ultimately the people will be the audience on the last day. Once you can appreciate and your friends also can appreciate your idea. But the thing is, if you are not changing your idea, if you are not going with the change, then suddenly somebody is really into the dark well. It's really bad for the designers. So these some ideas we don't discuss. So the thing is, when we watch our daily life, you can see the opportunity to solve the problem. So whatever you see, whatever irritate you, and then try to resolve it. If you are watching this tube, so you should think of okay, what should be the design of the tube, how it can be in a different form, whether you want to take a paste or you want to change into the powder or you want to change into a sticks or a different things you can change, right? So that will be your ability how you are changing. Even the soap can be in a brush, a toothpaste also can be in the form of a kind of soap. So you just have to rub your brush in the morning and just paste. So this also every time the idea generate, but you have to think and you have to check it in the society. Then only you will understand how design, because people think. So there are some very good examples why I like these examples. This is a matchbox. So this is very good and innovative idea, right? So I really appreciate this product. These are very small. These are small product, but millions of people are using this product in a day, right? Millions of people are using. This is of 1 rupee, but it increase the value when the million people are using this product. So you can see these products like the Velcro. You can see it also solve many problems. So many people are using the small product. It's not like I have to design Apple computer. It's not my field. I can't design ISRO ka some rocket. But wherever problem I face, I should resolve that. If I am facing a problem in the chair, I should resolve this. If we are sitting in the studio and facing some problem, then we should really resolve that problem. Then accordingly we can proceed for. So the safety pin also a very good invention or a very good innovation where millions of people are using these products, and huge number of piece and their company people are generating. So you can see the capability of these products, how these products are proving. Have you seen this is also invention, this button? Have you seen? It also had a patent. A lot of things had a patent, but everywhere people are using. So some royalty these people will be getting. If you get a single paisa, 1 paisa from millions of people, you will be billionaire, right? So you think of about yourself, generate the idea and try to save it, because this is some type of investment. What happens is people have a properties like land, they have cars, they have gold, they have a lot of things, right? So this is intellectual property. It comes from here. So this is your property. Nobody can steal from you. This will be with you always. So those people really thinks of they are capable of doing the research. They are really capable of doing the innovations. That capability nobody can steal from there. That you have to understand, right? It can change the life of the people. It can change the whole generation. When you design something new, this idea is also really capable, like in every office we keep, and yeah, very flexible, and everybody is using this without tearing the paper. You can keep all papers together. This is like a small problem solving device, but it's existing and numbers of people are using, millions of people are using. So everybody thinks like Apple product like is very good product. Apple products is also copied. You know, all the Apple products are copied because we are industrial designers. So we read about the history of the Apple. We read about, so it's not a copy, it's an inspiration. Should not say about this is a very big company, right? So you can see the examples. The Braun company have used the actual radio in 2050s or 49. So now they came in 2000 with the iPod. Then the monitor, we see the Apple monitor that is copied from 49. They had a speaker like this. You can see the calculator comes into the Apple mobile. The same type of visuals now they are showing into the virtual this type of calculator in Apple. So you have to take the inspiration and then you have to make your things better. So you can be successful, right? And never think of like one idea can. So I was talking about, I have a whole process of the design how to develop the design, right, in architecture. So architectural people has a lot of understanding about how to develop the design, right? So this is like empathy. Empathy is also very important. When you read about product designing, when you go through industrial design, then you will read about the empathy. Why you require empathy? Till the time you are not really humble, till the time you are not really understanding person, then you cannot really proceed for the design, because you have to talk to people where ego will go down, right? So people don't really talk, so design never comes. So what happens is like when you never love your design, so the empathy will be there always. Okay, so you have to do the research with the users and you have to understand the people, and those people really don't want to talk, then they cannot really understand the problem. If you have to design the cleaning device, you have to go and talk to the housekeeping people, right? You cannot once you are doing cleaning in your house and you will understand all the problems. Continuously all the housekeeping people are using this, so they will be knowing better than you, right? So we have to accept it ki we are just a point in the knowledge sea. We have to understand, we have to connect the dots, and will, because I talk to somebody and that other person will give you some idea, so there will be a benefit of myself, right? So we have to understand when we talk to somebody. So then we have to observe the things when we, so the empathy is very important in this field. So empathy is the first point in the product design. When you go into the product design course or any product design schools, so the first step everybody will say, this is empathy. Empathy is, you know, so if empathy will be there, so like what happens is like we when we love the design, what happens? The ego will be there, right? When we love the design, ego always will be there. How somebody can really refuse my design? In the juries, most of the thing happens. No? The students, I ask why you have designed. So sometime because they are in the learning phase. So because now if I get the chance personally to improve my products, even from the first year architecture, I accept that and then I try to change the products and change my approach, because I am beneficial to get the idea from the other people. Nobody else is really getting the benefit. That's why we found we filed a patent with the students also, 5 students, and Deepak sir and me also have filed one more patent that is in the pipeline. So it happens like, so though we have to hear the criticism of the product. So what happens is like somebody have told me, when you design something, you just ask to your dad and mom. If they are understanding, then everybody will understand your product. So I started asking my mom, like, so they never have seen a lot of things, but I used to explain everything from starting. I'll show you my project, what was my project, and then we'll go through the process of how I have proceeded for my projects and how I proceeded for the designing of it, and then how I applied for the IPR. Because when I completed my Masters of Design, from that time only, I started learning about IPRs. So because some knowledge we should have. So there will not be improvement if we don't have empathy, right? So total change in the nature should happen when we design something. So this is the simple process. This is the second step. You will see the problem finding. When the find the problem, then we analyze the problem, then concept making, concept development, concept detailing. So all these things you read in the architecture also. Mockup is like if I'm designing this mouse or this mic, so I will just make the thermocol shape of this mic. It will not be workable. I will make this button over here to switch off on. That will be mockup model, right? So you understood, I guess. If it's working, then that will be prototype. So when we make the first product, then there will be a numbers of improvement into the prototype. Later on also we have to test our this thing, the prototype. So sometime the company people give the free sample to the customers. Like I have seen the shampoo or a lot of cosmetics, they give it in without any cost, or they will give in the malls, like they will stand and just distribute the sachet of the cosmetics, like. So it happens, the other products they cannot really give the free piece to the people. So it happens, depends on the product, what type of product is there. So accordingly they can test on the people. And the production plan, then if we test the final product and the prototype, if we find the perfect and workable prototype, then we have to proceed for production plan. So what happens is, this is the process how we should proceed. So automatically you can reduce a one or two step, but the whole process, the agenda is like, if we have to find the problem, then we have to proceed for the solution. So if we are thinking about the architecture, I was thinking about the architecture. So many people will be having a thought of solving the issue of the door handles. So there are so many door handles in the houses. This is a part of architecture, right? So in this case, if somebody really want a comfort to open the door, so first you can see somebody want the security. Then second you can see there will be a sensors. Somebody want really the comfort, so the ergonomics factor you can see. So there are different type of somebody really want, if I am entering in the house and no light is there, without any light, so I will feel like my handle should be little shiny, the little amount of light should be there. So automatically if I open the door, then automatically the light will be there. So I should not really find the switch on in the room. So automatically it happens. The third you can see, the last one, in the first you can see mm, the locking system, the security system people have designed. So the same object, the thought process and what the problem finding, everybody had a different type of problem in the handle design, but everybody came up with a different solution. So the last one, the COVID-19 may we the person is opening the door from this part, right, from this part of the hand. So accordingly, you can see there are different approach and different comfort, different problems in a single or single type of object. You can see. So it depends on you whether which it's a good design for you or not good design. You have to find yourself, right? So everybody have a different choices. So accordingly, you should design first. You have to understand your problem, design for yourself, and get the feedback from others. Then only it will be authentic design. Otherwise you will always face the problem, and always we will speak. Our product should speak, not we should not speak. We should be silent when we design something, even in the building also, or anything. We should not speak, our design should speak. We should, if we speak, then we are defending ourselves. Sometime if it will be difficult to really understand, then it will be. So what happens, see, understand yourself, understand daily routine. These are some lines where you can proceed with the design. So automatically you will get the idea, and notice then in the notebook when you face a small problem. Architecturally we cannot, I cannot design I can design the case of the television, I can just resolve the issue of it, but that is also a lot when somebody get the experience of it, so it happens like. So where your expertise is, where you are really capable of design, you have to take the case and you have to design it. Understand the personal space, you have to understand your personal space. I'm sitting on the office, students are sitting in the studio, so you have the lighting, whether the light is hurting you or some type of reflection is coming, when you sit on the stool, so what type of stool should be there, or that you can, at least you can design for yourself. Later on you can file the patent, it will be. And what happens is, like, it's not only about when you really follow this step, the last procedure will be creating a business, right? So in the previous sessions also, madam already have explained about the IPR, how to file the IPR. The agenda is not to IPR. Where when you think different, if you file the patent, so you just think of you have the authority in whole country or whole in the world, like to you can produce this, you can do the mass production, you can produce by your own. Nobody has the authority to produce your own, right? You cannot, nobody can steal that your product. So you have to understand the people, understand the physical environment. So then only you will understand, and there should be a talk of the things where you people face the problem. Not talk about people, it should be a talk about the actions, how the actions we are performing. So it will be like, so automatically it can change the trend, it can change the life when you design something new. So it's so every great thought start with the pencil, then it will get the physical form, right? And then later on you will be having a different. So when you design and something with the pencil, so you have to make the patents. What happens is, like when we design the design with the pencil, so we are not really interacting with the things. Sometime we are reading about some person, but we face the actual person, then we will understand the actual type of all type of behavior of the person. So we have to understand the product also, when the product behave with you. So we have to design the prototype with the normal things. So how can we interact with these prototypes? So some architects have designed this, so I just kept the example of. So you can see the shed, right? So you have to see the problem, you have to do the manufacturing of it. At least you have to test one piece and then you proceed for the patent, then it will be really helpful for your career also, right? So these are different products in the architectural field, in the product designing. So wherever you face the problem, so in the starting also I had a little interest into the landscaping architecture. So I tried to design some type of windows with the venturi effect. I want to design some type of flower pots and lot of things, like I have a list of it, this. So first I just noticed down the, I noticed the problems, and later on we can think and we can chit chat, we can really talk with the friends about how to resolve it. So it will be a growth or of ourselves. We can really so you can see all the equipments and everything in the kitchen. So these are all set of the equipments you keep in the kitchen. So accordingly you have to use, where to use. So where you face the problem, whenever you cook the curry. So if you are facing a problem to cooking in the cooking, that also you can design, right? When you eat with the fork, if you are facing any problem, you design it accordingly. So there is a behavior, so the life is changing accordingly and the behavior is coming. So later on, so this was just the example how to proceed for the design process. So I will show you my some projects where you will understand how I proceeded with the designs, because I faced the actual personal, it was my actual observation, it was my personal observation in the environment. So I resolved it and got the patents on it. So it was not like the idea came into the mind. So what happens is, like I used to watch the clocks. So I have designed a clock. Yeah, so my observation was like we are watching the clock, but it's not really showing the correct time. So you know, you watch the clock, so every time you are watching. So what happens is, like you are celebrating your New Year before the Earth is completing its circle around the sun. So this was my observation. So I thought of to design a new clock where we will get the different experience of noticing time. Because every time I watch the clock, so it's all the needles are its movement is in a circular way, right? It's revolving around. So it give you a some type of tension. It gave me in the previous time. So I thought of to design a clock where it will not really give you a expression of. So I should not get tense, I should not I mean to manage time. So it was like really a very psychological problem, like yeah, I thought of it to change the experience of the clock and to change the approach of the clock and to bring some type of correction into the noticing time. We have 1 second. So what is 1 second? Anybody have a idea of what is 1 second? Definition of 1 second? Anybody has? Can anybody explain? What is the definition of 1 second? Every time you are, many people are wearing clock. I don't wear clock, but I'm asking those people are really wearing the clock, this wristwatch. So, so these things you people. So I thought in my time, like I was thinking of what is the definition. Then I went into the history, and then I thought of like there are different type of devices came into the market, and they tried to change the scenario. And are we noticing a real time or not? So the real time was like when the Earth is completing the whole circle of the sun around the sun. So that is one day, one year according to me. So on Uttarayan, you will see Uttarayan means Makar Sankranti. Earth is really completing the actual circle, and the day is shifting every time. In my childhood, it was coming on 13th. Now it's shifted to 15th. So the universe is also expanding. Now we will go into science, right? So how I related with the science? So the universe is expanding. So it takes more seconds to complete the circle, right? So I thought of why the clock is not showing the actual time. So we should have some type of clock where it will show the actual time, how the universe is revolving, how the planets are revolving. So there will be an impact of each and every planet on the human. That is Panchang. So I try to incorporate in the. So that is all mathematics. People have done a lot of research. So I went through the research, and then accordingly I designed a clock where the experience of noticing time will be different. Okay, so I have designed a clock, so I will summarize in just a shorter way. So I designed a clock where you will understand the movement of the moon, then you will understand the whole year timeline, then accordingly you will see all the planets, not the planets, you will see all the festivals on a different date, because you people celebrate your festivals also, right? So the date is shifting every year, right? So it's because of the planetary motions. All the festival date is shifting. So you should understand in the physical form which planet should be at what position. So you are celebrating your festival. So Indian person will understand his festival timing, and American person will understand his festival timing where he should celebrate. Otherwise, on the television, you will see news channel people are telling your festival is starting from 5 o'clock, 6 o'clock. When you design this type of clock, you will understand automatically from your clock when you have to start your festival, right? So this was all mathematics. It was not a computer science or some prediction is happening. So this is all just like a movement of the planets. So we are celebrating our festivals. At the same moment the planet is coming. So the other next year we are celebrating our. So I marked all the planets in the second circle. So and the third circle, fourth circle, and fifth circle was the ordinary. This was hour, minute, and second. So there were 5 timelines where you can understand about. First is the moon position, and moon position is also have some complications. Like when it sometime the tithi start, so you will understanding is tithi also in this calendar. It's not just like a day. So many people already gone through the panchang and they knows about tithi and all these concepts. So they will understand how the tithi is shifting and how the date is shifting. The English calendar is not from Britishers. You know about where is the it generated. Okay, fine, I have done the research. So okay, there are so many complications in the time philosophy. So I designed the new clock. I got the IPR on the I got a 3 IPRs on. So one was like a daytime and the other was the night time. So it will show you a day timing also. So it was like digital also, and the reflection of the movement of the planets. So where the planet is moving, accordingly you will understand. So at least they had. So I designed a clock in this way, the minimalistic way of moving all the dots. So I connected it, and this type of minimalistic time. So if somebody will send this graph to somebody on the mobile, so you already have captured the movement of the planets together. You captured the moon movement, you captured the sun movement, you captured all minutes, second, and hours when you just show this sign to somebody. This was the concept behind designing the clock. So this will be the it changed the totally experience of myself when I observe the time. So it was so the second project. Okay, so this was a clock project. It was my thesis of Masters of Design. I used to think like that, and many friends industrial production will happen. I'm not going to use. I have to understand the problem and I have to resolve it. So that was the issue. Okay, so that was the procedure of developing the product. So I asked a lot of people, almost the whole college, and a lot of people used to know and give the feedback about it. Even the canteen people gave the feedback on the clock, because I used to go to canteen SP Delhi and I explained this clock, then he also give the feedback, "Ki it should happen like this." So many people give, but we have to understand where should and what we should keep. This was the second project I have done in under Design Innovation Center, SPA Vijayawada, where we had to work on the portable house. So we made a portable house, and it had a different type of mechanism. Like you just have to open like an umbrella, so you can I mean transport everywhere. It will be easier to open, and it can accommodate for the emergency purpose to anybody. Okay, so this is the project. Recently, the director sir also helped us, and in this design, we were working from last 2 years. This is not also ending. We filed the 3 patents, and then accordingly, this was a lean to seat. It means we can place this type of railing or this type of furniture, because it can be just the half of it. So just on one side, we are exposing two side of it. So the person, it can give a support to person, just a minimum support. So in foreign countries, you will see this type of lean to seat is there, but in India never came. And then we tried to myself and Deepak sir also have worked on this design. So we came up with the 4 designs. We filed 3 patents on the design patents on this, and we received a 1 patent and 2 examination reports. Still we are working on it, and then we'll improve it. So this is not the ending. If we try to fit these lane to seat in the college, then accordingly, if the good feedback will come, so we will improve it. It's not like this will be the ending point. We will improve it, and then accordingly, because Indian anthropometry is different, we have a separate height. Even the kids are coming, and a lot of different height differences also there into the people's height. So accordingly, in this model, what we are showing on the screen is like little bit comfortable for a different heights. It will give you a support of different for the different type of people. Yeah, so we worked on this. I made the prototype during the time 2 years back. I used to work in the workshop, and then we gave this type of form, the fluidic form, into this, and then this year only we filed the patent. This was the umbrella house I was talking about. Yeah. So the Q pad is also menstruation cup, and the joining of a pad. It was done with the students of 5th year. The student is passed out now, so we filed the patent. This is under pipeline. So we already have sent the design to the IPR office. So this was also inspired by the local art, Kalamkari art. So what happened? Like we visited for the we visited this village, Kalamkari village. This happening in Pedana village. So what happened is, like, we observed the things, and we were thinking of, like, people have to separately make the colors, and they are dipping these stamps, and then they have to apply on the fabric. So it was very difficult to work with, because their environment was like some type of a lot of problems are there, ergonomic problems. Every time they have to dip in the color, and they have to apply on the fabric. So even the less timing is also there. The complex usage of this thing, refilling, a lot of issues were there. So myself and Faisal observed this problem, and we worked on this, and we came up with some type of solutions. So we tried to make because what happens, this work can be done by the machinery. So we don't want to discourage the local artwork. They should not really remove this. Ki, I will put the machine and it will automatically do. Then where these people, those are working manually, where they will go? Right? We have to take care. We have to understand their life. We have to engage them, so they can do a more they can increase the efficiency of the production. We should not totally remove the people, right? We have to give the support to the society. So we designed the stamps like it should be automatically. At least the person will be very comfortable on the seat, and they will just mark like a stamp. So it will be like this. So we gave the solutions, and these were the solutions. So these are the basic models. we have prepared with the help of the carpenter, and then this is the model. Still, it's going on. So we are connecting with the artisan, and then accordingly we will make the prototype in a lighter way, and then it should be more efficient. So you can see few designs has a just one plate of designery, and few plates has a four. We can revolve it and change the designs. So we are working on this concept, and we applied the patent, and ma'am is handling the file. So ma'am already have discussed in the starting also. So yeah, this design also we have to file the patent. So first we will apply for, to save our idea, we will apply, we are applying for preparing for design patent. When the instrument will be ready and the working will be ready, then accordingly we can file the utility patent. So for the movement and the inking thing, so all this usability we can file the utility patent later on. So these are the ergonomics pattern. So how we have to handle. So first we were understanding, I was understanding it's very difficult to hold the this stamp. Okay, so the wooden this blocks, and so we made the ergonomics this thing. So these are the different examples. So yeah, we already have explained about, these are already ma'am explained about the IPR and what is the value of it, how many categories are there. So you people can just see. So what happens? Yeah. So the last impact, whatever the journey I have, I mean traveled, I mean crossed till this position. So what happens is like we have to, we have to incubate the product, right? That is the main agenda. We are getting the IPR, then we will incubate the product, we will make the final prototype, and then we will establish the startup on the product. That is the main agenda. So if we are working on a 10 products or 20 products, then genuine one genuine product can come in the market, right? So it's not like, so that's why I was telling about never love the product, because if we love the product, we cannot leave. Even in any field, if we love something, we cannot leave. So if you love your product, then you cannot leave. So it's not you should hate your product, it means you have to accept all the thought, then only you can proceed and complete your journey. Fine. Okay, thank you.
Thank you, Pushpendra sir. Very good presentation. Really a practical experience he has actually hold it. In fact, don't love the products he's saying, right? Don't love the ideas he's saying. So if you don't love things, so many problems sometimes. Anyway, thank you very much. Now the next presenter, our chief guest sir. Now I request Professor Vijayalakshmi Madam to hand over the bouquet to our chief guest sir, Dr. Bharat. Photograph please. So before presenting, I'm just introducing Dr. Bharat. Dr. Bharat N. Suryavamsi, Assistant Controller of Patents and Design from Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. It is a central government organization under the Patent Office, Ministry of Commerce and Industry. Presently, he is working at Nagpur office. He has completed his Masters in Biotechnology, PhD, from Swami Ramananda Tirtham Marathwada University, Maharashtra. And he has published various national and international papers, and he has delivered many lectures on IPR in various parts of the country. He was deputed for training at Tokyo, Japan on examination and IPR issues. He has been part of various judicial, national and international training programs regarding the IPR practices. Has given a landmark decision by rejecting Pfizer patent application for arthritis drug which was filed in India. And now we invite you, sir, to deliver a lecture on introduction to intellectual property. Thank you, sir. Please. Yes, yes.
Hello. Hello. Yeah. Good evening, all. I'm first of all sorry that I should be present in the morning, but my train is late. I always 1 hour before my. So first lecture, ma'am has taken what is intellectual property and some kind of that. I leave that part. I'll cover others. What is trademark? First, what is patent? Just in brief, because I'm working in that field. Again, copyright. Then I'll go how to write your patent application. Then how to file your patent application. And sir has already dealt the designs. Now how to file designs. So I'll cover this much only because it should not be repetition and should not be feel bored. So first of all, I should introduce my offices. Many people are still new of IPR. We are having different patent office at different locations like Kolkata, New Delhi, Mumbai and Chennai. These 4 jurisdictions we are doing examinations and you are supposed to file your patent application in those areas. We are having only one training center, that is in Nagpur. We are giving physical trainings, classroom trainings to all the departments, faculties, students from 6th to all, because small project designs, technologies are done by the students who are in 8th, 9th and 10th. They are doing best projects, so we are giving training to them also. We are having trademark offices in addition to 4. One is at Ahmedabad, Gujarat. Geographic indication office at Chennai. These are the pictorial view of our offices. This is our training center. Again, this website, if you are not knowing anything about the IPR, please log on to this. You will come to know about the different intellectual property rights. Again, we are keeping updates on social media. If you want to join, please see this and join the programs which we are conducting at RGN IPM. Let us see today's topic, what is intellectual property? You can see my slides. I have shown something blooming in the mind, lightning in the mind. It means I want to convey you that the product of mind is called intellectual property. Now, the question arises, what is product? For example, your architect planning, if it is the form of literary, you can go for the copyright. That's an idea is coming from your mind. For example, somebody is developing new name for your business or startup. That's the name is arising from your mind. That's a trademark, is an intellectual property. Or if you're developing some new technology, new design, as Pushpendra sir said, that's again arises from your mind. Therefore, simply we can say the product of mind is called intellectual property. Now, let us see how that property arises. When you are the professors, some are the students discussing with your students and professors on particular topic, particular design, and trying to solve some problems. As sir told, if you find the problem, you are trying to give solution for that. How the idea is coming? From your mind, from your discussion. Therefore, any idea, when you are alone, in group of people, or with students and professor discussing on a particular topic and trying to solve some problems. So problem solution approach, if in the form of design, you can go for the design registration. If you're giving for the technology, you can go for the technology. For example, how many of us we are using shampoos for our hairs? Everyone. Earlier only once in week we used to, daily we are using shampoos. Somebody using Vatika, somebody Sunsilk, Dove. Now many of us using Wow. In my family they are using. Why these are all? Are they really curing your dandruffs? No one is thinking. Some heroines, some famous people are advertising, are we using. But you are also in your own field. Something new if you are doing, you can also get patent if it is technology. Or any design to put that shampoo inside, or pouches or pockets, that you can get design for that. So anything, any idea which arises from your mind are called intellectual property. It arises during discussion in the group, alone or in this. So keep in mind that. Simple example. Do you know? Australian company has developed a smart shoes for the blind. There was a problem with the blind people how to walk, how to find the obstacles. So somebody thought on that problem, given the solution. So you can get patent for that if it's technology. If you're giving shoes design, you can get the design also. How the idea is coming your mind. Again, one of the scientists in Nagpur, Dr. Pise, you know Moa flowers. Maduka longiflower is botanical name. Earlier, it was used to prepare liquor only, but on September 4, he has produced that cold drinks from that Moa flowers. What is that? Again, invention, technology arises from his mind or his research. We can say that's again an intellectual property. So, in your own field, if you're civil engineering, mechanical, electronics, or architect, depend upon you. You can. Somebody is developing ceramic composition for tiles. What is that technology? Because you want to give strength to your tiles which is there in the market. So again, ceramic composition or process of making composition, again in technology, you can get patent for that. And design, ceramic design, how you are making, you can get design for that. So everywhere is technology. You can get protection, but we are not aware of that. So please go for protecting your technology. See, these are the examples of technology. As background was taken by ma'am, as we say, we are having property. Property means our mind directly goes to the physical form of property. We say, I'm having car, gold, plot, flat, even land in my native, so I'm rich enough. But don't say like that. The property that is intellectual property, as sir got patents and design on his work, it's an asset like any other form of property. You can get more than that. As madam has covered different kind of IP, that's patent, design, trademark, so I don't want to cover. Directly, I'll go, what is the definition of intellectual property? IP means intangible, means we cannot touch the creations of whom? Yours, because we are creating that. Our mind is creating, therefore, it's an asset like any other form of property. For example, at present, if you're developing new Omicron vaccine, already many actions there. If you're developing something new, then you can license to anyone, you can get money out of that. Therefore, again, it's an asset like any other form of property. Earlier, there was no solar panels. Now you are having. What is that? Idea came from your mind. So again, that's an intellectual property. IP is called as an exclusive right. For example, from this institute, our alumni of the student has got patent. So he is the owner of that. He is having the right to sell, produce, or whatever he want to do, he can license also. No one else, not his brother, sister, or teacher also. Therefore, it's also, we can say it as a negative right, because other person cannot exercise the power of that. Again, it's an territorial rights. Once you are filing your technology, product, process in India, it's valid only in the country of India. If you want to establish right in other countries like USA, Japan, Germany, or any other country, you are supposed to file your application by means of two-way. One is called PCT, that is Patent Cooperation Treaty. Another is called Convention Application by means of Section 135 of the Patent Act. In this PCT, we consider best because single application, you can designate all the countries where you are interested. Wherein convention application, each application you are supposed to file in different countries. So many prefers PCT. So you can protect your IP in the foreign country also. Let us see what is patent. How we can define. We know what is patent means technology, something new, but how to define? Exclusive, monopoly privilege or right granted by the government to the patentee for 20 years from the date of filing, or priority when you are disclosing everything clearly, then only you are getting the right as entitled. Section 10(4) of the Patent Act says that always give examples what you are doing. For example, if I am taking a device patent, so how my device is better than the others? You have to explain detailed expression. You have to give the drawing of that and how it go. We can take ATM machine. It's an technology. When I got job in 2003, we used to take salary in the hand by cash. Now we are having ATMs to draw. What is that? Again, technology. So how it is? Combination of hardware and software we are getting the money. That's a technology, and we can get patent for that. Many of us, while doing our research, many BE fellow, MTech fellow are doing the research. But still, we don't know whether our research is toward the discoveries or invention. So while starting our research or project, we should understand whether we are doing inventions or discoveries. For example, tire, we are doing invention because rubber is already in the market. We are manufacturing the tire, it's an invention. Another in case of biological sciences, microorganism. We know if I'm taking project to isolate microorganism from your campus, the process of isolation may be new because I'm using new technology, but the microorganism is an discovery. So we should understand whether my research topic, whether my PhD topic is an invention or discoveries. If it is invention, first time somebody is doing, please go for the patent filing before the publications. So identify yourself as an invention or discovery. When we can say it's an invention. Invention means it should be product or process. Product means ATM machine, CT scan machine, tiles, cement, composition is a product. Process of preparation of beverages, process of preparation shampoo, these are the process. So your topic should be either product or process. Again, it should be useful to all. Again, it should be new. It should not be in the public knowledge. Again, it should not be obvious. What is obviousness? I'll tell in the next slides. Again, whenever you are filing the patent, you should not have the data or information before that in the prior public knowledge. Then definitely, primarily yourself, you can judge my project is qualifying the definition of invention. I can go for the patent filing. Let it go after that what examiner does in the patent office. But primarily before filing, you should identify yourself, it is invention or not. If yourself says, or your project team says, or your research and student says that really it's something new, please go for the patent filing before the publication. Simple example, sharpener. When I was studying the small village of Karnataka, we are not having sharpener. I used to use the blade for sharpening the pencil in 5th standard. 1st standard, we don't have a pencil also. But now, even since LKG, where what is that? It's invention, but we are not. Sir has given clip example. Invention, button, zip, all these are inventions. Somebody brought first time technology in the public, they got patent. You may be scientist, you have ordered many PhDs for the students, but you are not inventor until unless you have a single patent on your name. We can say him as an inventor because you got the patent for that. Like in the general knowledge, in the school we have studied who has invented aeroplane, who has invented vaccine, who has invented many things like telephone. So can anyone tell me now, this telephone was already in the public domain. You might have seen the old Telugu movies, Hindi movies, Marathi, Kannada and all. But someone thought to give the mobile phone. How the idea came in the particular mind that he should have something advanced than this telephone? Anyone please? Why someone has got idea to develop mobile phone? Why he thought that mobile should be in the public? Because even this telephone we are used to talk with the foreign country also during the British period. Why someone has got idea? Why you and me are not getting ideas so that we can file the more patents? Yes, to reach. You from this also I used to reach to call London everywhere. Again, okay, again. Yes, portability. Again. Size of yes, many things. See how you are thinking. So why can't you think during your project giving to your students? You any project guide is giving project to students. Why can't you think like that? Already ceramic composition for this is available. Why can't you do something improvement? Any device, why can't you think? Why can't do something like that? Somebody thought we got the mobile phones because this is having some disadvantage. One, I cannot change this telephone from Roycer's cabins to ma'am cabin because it's connected to a particular point. I have to go Roycer's cabin, I have to speak there only. It's one of the disadvantages of that. Again, for dialing, 10 times I have dial, time consuming. Who is having time to dial 10 times? To solve that problem, we got table phone which we are having now. There, directly I can dial 1, 2, 3, 4. But again, I cannot change from sir's cabin to ma'am cabin. Again, it is correct for the point. To solve that We know many of the serials showing cordless phone. We can take in the hall, kitchen, drive, nearby area while talking. But we cannot take in the meeting, nor in the car, nor in the train, nor in the plane. To solve that problem, someone thought, and we got the mobile phone in India in the year 2000 or 2002, if you remember. And simple Nokia mobile was there. Students may not remember, Professor can. Simple Nokia mobile, heavy silver cover, but price more than 5,000 rupees. Now 500, 1,000, 2,000 up to 40. What is this? Improvement of technology from AG bell to mobile phone. Only incoming, outgoing there. Now we are having video calling facility. Google Meet, Zoom Meet. What is this? Improvement of technology. So always do improvement as sir told. Your design is don't love, let it disgrace. This somebody disgrace telephone, we got mobile phone. So always that point is required. Some improvement should be there. That may be mechanical, electrical, civil, any field. For example, already I'm having cement composition, having so and so percent. But I'm doing improved cement composition comprising so and so. If I'm showing good results, good strength than the earlier cement, no one can stop you getting the patent for your cement composition or tiles composition because you are showing the strength of that is there. Again, I'll take one of the pharma example because I talked with this pharma people also. You know, many medicines are there. For example, paracetamol, very common. We say somebody is having fever, please take the paracetamol. Your fever will be reduced. But how much time it takes? 6 to 8 hours to reduce your fever. Somebody from pharma, biotech, is coming with improved formulation of paracetamol. If it is reduce your fever within 2 hours, what is this? More therapeutic efficacy, showing good results. So improved formulation of paracetamol, you can get patent for that. So I want to convey you all message that don't think getting patent is very difficult. If you are improving small devices, small process, definitely you can get patent for that. I'll quote another example for the process. Many of us teaching faculties thinks that अरे patent मिलना तो industry वालों का काम है. Why industry वालों का? Already one of the fellow faculty, alumni of your college has got the patent. Why can't you and me? So please think that solve any kind of problem that may be any field, you can get patent for that. For example, we are doing Maharashtrian people, most of them, even everywhere, we are making Ganpati for 9 to 11 days. What we are doing? We are preparing different modakas, different garlands, grasses we are making puja. Ultimately, what we are doing? All waste we are throwing in some pond, river or lakes in towns. In Mumbai and all, they'll make artificial seed, that is different. But in other districts, directly pond. What you are doing? You are polluting the aquatic life. You know, food chain, food web scientists are knowing. So you are harming that. Somebody among you develops herbal method for treatment of pond water. You are solving the problem. So definitely you can get the patent. No one can stop you. आपको उसको patent मिल जाता है. So get every problem. If you are giving solution, you can get patent for that. So don't think that getting patent is difficult and teaching faculty cannot do. All the inventions are coming from the teaching faculty only because you are the people daily studying subject matter and doing improvement, not a scientist. Here is the bank of the knowledge. So you have to put your children to be in research and they should file more and patents. Then we can compete with USA, China and many other countries who are filing more patents in the world. So please be aware of that. Again, you know, mobile came, but Bluetooth was not there. Now we are having Bluetooth. We are transferring notes, movies and all. Nano car was not there. Mahindra, Tata were there, but not Nano, came in between. These are the examples of technology. We can get patent for technologies. And these are the different drones, smart card, came newly. These are technologies. Designs already sir dealt. So I want to go, don't want to go with that designs. Pharma people, you can see your design. Sir has not showed pharma design. So pharma people, you can get syringes, ampoules, capsule design also. If you are having new, you can get registered. You can check the 2 designs of capsule. These are different. Syringes you can check. Ampoules, you can get such type also. Sir has taken many examples. Even jewelry designs, curtain designs, bedsheet design, earrings, bangles, watches, all design you can check. I'm using simple watch. Many of are having stylish watches. Mobiles, you can check the design is different. Earrings you can check. Bangles, water bottles, office bag, college bag, your Mangal Sutra, any design, if it is new, you can get registered. Even curtain designs. Earlier, ladies used to put some design on this cloth in the villages, but they are not knowing how to approach the textile companies. Therefore, they are lacking. We should make aware of them. They all are on sari designs and curtain designs. Even daily consumer products, wallet, office bag, combs. Everyone is having different comb. I am having this type of combs is a new design. This is a lamba comb, my short comb. So it's new design. So anything which looks beautiful, that's a design. How it works, that's a functional feature, that's a machine. How freeze looks, LG freeze and other company freeze, we don't bother. How it works, how it looks, it different, new design. IFB washing machine is there, LG washing machine. Both designs are different. You can check as a scientist or a designer. Both are different. Even water bottles of Aquafine, Aquaguard, Sunreach, many are there. Rail water, Niri water, we never think. When we are students in the year 99 in Gulbarga University, we used to go for the parties after getting more marks. What used to take? Poha Pakoda, because 10 rupees in the jab. Now students are going for Coca-Cola, Maaza, Sprite, pizza, but they never thought why Coca-Cola bottle design is like this, why Maaza design is like this, why Sprite is like this. Ever anyone? Even we are also now doing parties. Anyone has thought? We never think. If you think innovatively on each concept, then only you can create a design. If you want to create history, we should know the history like that. If you know the design, we can create something new design. You never thought why Coca-Cola is like this, why Sprite is like that, why Maaza is like that. These are the new designs registered by the particular company so that other company may not copy the design of that. So that's a branding name or design name. Again, see, even safe configuration of the bottles also a new design you can get registered in the Government of India. Even in this sharpener, pencil, we know sharpener, but dual in nature, new design. Earlier sharpener is known, but I'm making due, it's new design, you can get registered. So where is the difficulty in getting registration? Nothing else. You can see new designs, dress designs. Again, this was designed by one of the students while doing the project, Vikram Deenabhai Panchal. Can anyone tell me why someone has got idea to develop such kind of design? Anyone, please? This is belongs to construction companies. Yes. So this fellow is getting, why can't we do the project? Especially I can tell if students are there, if they want to do project, they first go to the library. They see what senior has done. Similar topic they choose and mere change in the data to get a degree. Really, if you want to be a researcher, don't see what senior has done. What is prior public problems as sir shown out many slides, search the what is problem. Then go to search your topic, what to be done. In this slide, this fellow of design want to do project. He went to the many construction site. He talked with the many coolies who are working since more than 5 years. They told they are having neurological disorders. You know, nerve connections we are having, we are all science background. Back pain, disc pain. To solve that problem, he has developed, you can check carefully, the weight is not directly on the head. It is above the head, mostly it is shoulder. Distribution of weight, again, physics formula. So he used scientific knowledge in the construction of design. It will come in the market, but he has filed the design application for this. So again, the idea, how that idea is coming, he is thinking. So everything is product of mind. Again, integrated circuit is one of the kind of IPR. If you are having new circuits, we are using Taiwan chip, China chips. If you are having own design, physics people, electrical are doing this. If you are having, you can get registered in the Government of India, 10 years term for that. Again, ma'am might have taken what is trademark, but there are different trademark also, like collective mark, certification marks, taglines, slogans, and so. If you want to develop new mark for your company, you have to prepare the new name or mark. You have to file it, go for the examination, then publication. If someone want to oppose, they will oppose you. Otherwise, you have to reply for that report. If any opposition comes, then opposition potency will be there. If you are able to satisfy all the grounds of opponent, then you are getting register your mark like Google, Adidas and all. Then you can use R encircled. Otherwise, simply you can use TM only. Again, geographical indication. Place names used to identify source of origin, quality, reputation, or other case of products. Like some Bandar Laddu, something in your side. That is GI tag got. Even Darjeeling tea, Kanchipuram silk saree, term is 10 years, it can be issued like these are the different kind of GIs. Some are natural, manufacture also. Makrana Marble Rajasthan is a natural, but Ratlami humans, that silk sari again is an silk. Here in patent design trademark, anyone can file the application. Combining with a teacher student, company can. But in this GI, a group of people who involved in the manufacture of particular product, they can only, not in single person, because in group people work. So term is 10 years. You can get extension for every 10 year if you are interested, or if it is using this. See, these are the different kind of GI. Even agricultural products like Maghai Pan, Devanelli Pamelo, Apimudi Mango, Kashmiri Saffron, there are different kind of GIs. Let us see what is copyright. It very much related to your field. Many of these people, architect, most of the plans may not get patent, but they can go for the copyright. It provides its holder right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term is life of the author plus 60 years. Therefore, you might have heard many singers are no more, but still they are getting the royalty for that. The books which we are referring now, the author may not be there, but still they are getting the royalty for that. As if you are writing books, novels, stories, autobiographies, or poems, any literary works, it comes under section 2 of the Copyright Act. You can get registered in the Government of India. If you are doing artistic work, under section 2C, dramatic, 2, section 2, again, musical works, sound recordings, even cinema, means all kind of work getting protection. You might have heard my dialogue has been copied. Telugu movie Hindi mein dub hua. What is the dubbing and all? Copying, infringement of copyright. But you know, Indian courts, if you file infringement suit, it takes years to get. Picture aayega, chalega, kamaega, jayega, but no result at all. Therefore, we being a citizen of this country never feel much importance. But if in the same industry, there is, you see one of the movie, Telugu movie, Shyam Sundar Roy, the dubbed in Hindi, all copyright matter has been discussed in that. Three Idiots, patent matter has been discussed in that. So many movies are also discussing about the patents, copyright and all. So many, even the dialects copy the same, even if you are handling that harmonium in the R, that is that any first movie picture also, same type if you are putting on your screen also, that should not be. It should be different from others. Like Telugu here is in style, some standing, you cannot copy in the Kannada or Hindi also. That's again in the infringement of copyright. Another kind of intellectual property called trade secret. Some data, invention cannot be protected under the IPs like patent, design, trademark, copyright. Therefore, they are maintained secret. As till today, we don't know the formula of Coca-Cola, Maaza, Sprite, or content of pizza because they are maintaining as a trade secret. Don't disclose to anyone, maintain secretly. So any recipes, if you're having any ideas, survey plan, scientific formula, anything if you're having secret, you can keep that we call as a trade secret. Again, we can get protection for the plant varieties also. Many people are bringing new plant varieties. Earlier only Jaya, Pusha, Padma are the variety of food grains, many fruits. So if you are bringing any varieties also, you can get registered in the Government of India. I have taken simple example to make you understand how we can protect your technology, device, design by IPR. You can see by symbol, Apple is a trademark by knowing it. Overall design, you can get protection. Display is a technology, and inside that circuit can get protected. So that other company like Samsung or any other company will not, Dell also cannot copy the technology, nor design, nor circuit of Apple. So this is a way of protection of your property by different means of IPR. Even mobile you can check. Nokia, Samsung, they got patent for that. Let us see what are the career opportunities in this IPR. If you want to come in the Government of India, you should have qualification of any branch of B, means any branch of B you can understand, depend upon the vacancy advertisement. MSc in chemistry, biotechnology, microbiology, physics, you are all eligible to come as an examiner of patent and design in the Government of India. There are two papers, one is objective, another descriptive, then YOC. If you want to come as an exam trademark or GR copyright, you should have a law background. Again, if you want to come and patent agent, any science graduate, BSc, BCA, BE, BDS, any science graduate can become patent agent. Every year we are called for that. Two papers, one is objective, another descriptive, then YOC. Then if you qualify, you'll get patent agent number and you can practice in the IPR field. IPR cell, IPR policy of central government, state government, MNCs. There are many IPR firms in big cities like Hyderabad, Mumbai, Bengaluru, Karnataka, everywhere. So you can work in the IPR firm also. These are the career opportunities many of us not knowing in the IPR. Now, as I told you, you will be professors, faculties, students, but you are not inventor. If you want to be inventor, by simple approach, while carrying out research or a project, identify some problem, solve that problem, you can apply for the patent. I'll take simple example. You know, sir has sold many mosquito catching devices. I'll take similar example. You know, mosquito catching bat, sir has not shown. Everyone will use mosquito catching bat, but if you observe or not, I don't know. Knowingly, unknowingly, if you are putting that mosquito bat on, it gives small shock, but we never care. But children will cry for that shock. To solve that problem, that's my problem. To solve that problem, I am having computer background, so I am preparing digital mosquito catching bat. What is that? It recognizes human hand. As when you enter the mall, doors are open. How it recognizes? Same way, it recognizes human hand. It never gives shock if it is on also. There was a problem. I am giving solution for that. It's an invention. So I solved problem. No one can stop you getting patent for the digital mosquito catching bat. So always in your field, search the problem, give the solution. You can get patent for that. Now, what is patentable in India? There are many things in India, but what is patentable? As your architect plan as such is not patentable, you can get design. Same way, method of treatment, plant as such, animal as such, method of presentation are not giving patent. Only product, process, devices, all get patent in India. So to get patent, your research topic should be qualify the definition of invention in that novelty. What is novelty or new? Your research work should not be published in India or elsewhere. If you are filing patent for any tiles composition or process, we search your composition throughout the world. If it is not found, then we can say it's new. It should not be published anywhere else, not only India, throughout the world. Then we can say your research topic, your composition is a new, you are qualifying one of the definition of getting the patent, that is novelty. Second requirement is inventive step. What is inventive step? Feature of invention that involves technical advancement as compared to the existing knowledge. Example, I told you AG Bell telephone to mobile phone. What is this gap? Technical advancement. Or having economic significance. Earlier, simple Nokia mobile was more than 5,000, now 1,000, 2,000. What is this? Economic significance. Or both, that make invention not obvious to a person skill in that. I told you what is obviousness. I'll tell you next slides. Now, time to tell you what is obviousness. We speak while making. Making idli, very obvious. Making dosa, very obvious. But what is that obviousness? For example, I am preparing a tea. I am writing a patent application for the tea. A process of making tea comprising steps of A, taking cup of water, comma, B, adding cup of milk, comma, boiling and adding pinch of tea powder and sugar as per the taste, boiling, filtering, full stop, my tea is ready. Second claim, process as claimed in claim 1, wherein one of the ingredient in the tea is ginger. Means for the enhanced teas, I am adding ginger from this Andhra Pradesh. From Maharashtra, I am adding one of the lemongrass for the tea, or kavlaya chamula, means some roots of medicinal plants in Maharashtra. They will add. That is called kavlaya chamula in Marathi, and roots of medicinal plants I can see, or lemongrass they will add. Where in Gujarat, if you go, they add cardamom for the tea. So somebody from Andhra visit to both the state for the international conference. He saw the tea. It's very obvious to him to prepare the tea by using kavlaya chamula, roots of medicinal plants, or that cardamom. So to get the patent, it should not look obvious to a person skilled in that. Now, who is the person skilled in that? if you are filing civil application, any civil engineer or diploma in civil person is a skill in the art. So it should not look obvious to him, means easy to him to carry out the process. So it should fulfill the requirement of inventive step. Another requirement to get the patent is, now we can see how we can say it's fulfilling. Surprising result if you're showing, or you are solving long-standing problem, or fulfilled of a long-felt need, or a great technique progress if you are doing, you are qualifying the definition of inventive step. So something new if you are doing with the great effort, then you are qualifying the definition of inventive step. Third requirement is it should be made or used in the industry. So it should qualify this. If you are qualifying these three, no one can stop you from getting the patent with respect to section 3 and 4 of the Patent Act. Section 3 says non-patentable invention. Section 4 says atomic energy elements are not patentable. So this, except these two sections, and you are qualifying novelty, inventive step, and this industrial application, no one can stop you from getting the patent. Now let us see how to write the application for patent. You are having the composition of tiles or process, but how to write that? Essential contents are title and preamble of that. It should require. What happened? Please check your thing. Something happened. Yes, yes, ma'am. You can. Please don't think that I'm presenting. Please ask the questions also. No problem. Yes. Not like that. I'll tell. Yes, first, I'll answer first. Okay. Second. Yes. Thank you. I got it. Yeah. First example, once you are filing the patent application, we are publishing within 18 months, means after 18 months. If you are requesting for early publication, you are filing the form 9, then within 1 month or a week. Publication, it means not an your invention is good like that. Whatever you file, we publish so that public should come to know what you have filed. If you want to oppose, I can commit that. For example, you are filing ceramic tile composition for so and so. Such tiles composition already in the public domain, so I am also involved in the manufacture, so I can come in opposition. No, the component of this tiles has been already in so and so big, so I can file an opposition. For that, publication is must. Publication means your right start, but you are not getting the right for that, because still you have to prove whether your composition new or not when it in under the examination. Once it published, then it go for the examination. If you are filing form 18, that is called request for examination. You are paying the prescribed fee, then we start for the examination. It go to the examiner and controller automatically, because we are having auto allotment system. We don't see name that it's from Andhra, so I am the alumni of this college, I should come to me. Not like it. Automatically go to them. Then what examiner does? They search your content, what you have filed, what exactly your invention composition or process or device, where is your invention. We put in the search. There are many search database, paid, unpaid, free also. We are having Patsy in our office. We search in that. Even other search engine also. If you are not finding your composition process in that search, then we say your process is new and we are not putting any objection. We are getting grant. If you are having some documents, such composition, we forward to you. That is called first examination report. Then you have to reply within 6 months. This is the meaning of your publication and under examination. Yes, please. Very good question. Many happen things. If I am claiming ceramic composition of tiles and process of preparing the single patent, because use title C, ceramic composition for tile and process of preparation thereof. How? Title is simple only. But my product is different, process different, claiming one, and they are not linked with in single inventive custom, not related to same field, then we ourselves, as per section 10.5, we divide your application. We says you in the report, ma'am or sir, it appears that plurality of distinct invention. Plurality means many is in this file. So please divide the application according to product and process. But here, tiles composition process same, so it's same single unit construct. Therefore, we are getting single patent for this. Product and patent are different. Then we are telling you to divide. Then you have to divide product patent something and process patent something. Then definitely you are getting 2 patents per product and process. Any other doubts, dear participants? Yes. 50 patents. Yes. Yes. Yeah. Yeah. It's yes. What happens, especially don't take otherwise, teaching faculties. They want patent for the namesake to make strengthen their biodata. So simply they file process by changing pH, temperature, media, no use at all. But what we do, we don't know they will never commercialize. So they are showing something new, we grant the patent. But what is the use? No use, and they never renew also. 2-3 years they renew, they stop. But they to say themselves in the lectures, they say themselves in the biodata that I got 20 patents, 30, they put patent. But such type patents will never commercialize. This is just to add your biodata. But really, if you want to earn something, single patent, if it's really new, definitely you can earn like anything. No need to take many patents. But teaching universities also made some columns like how many published, how many grants, so they have to put. So bechara fellows, what they do, so they file the patent and they get. And they never pay the fees. They take from PhD students fees and PhD students guide, every will contribute thousand of fees and they take. So it's not good. But today when everyone wants to be selfish at some point, so make their butter strong and put them NAC report A for their college. They do all those things, but there is no use at all. See, already solar panels we know since long, but now no one use. Now everyone is using. Why? How long we know solar organics can be converted, but no one has used. Now everyone is using solar panels. Recently, why so? You know, simple example I'll take. Cylinders, gas in the home. Every time if I want to book cylinder, I'll lift both hand. I'll check. अरे अभी थोड़ा है, next week book करूँगा. और उठाऊंगा मैं बोलूँ next. Why so? We are in 21st century. We are having a knob which can indicate the how much gas is there. Why can't we are using? So India is like that. So we are like that. So we are doing like this. Otherwise, US and all, they never filed this patent. Simply why they want to pay the renewal fees loss. So which are good patent, they are only filing. Therefore, mainly working patents are very few. You can check getting patent many, but working are very few. So simply they are getting project and they are filing the patents. Yes, any other question? My talks never complete, so let the slide go. Your doubt should be complete. That is main my motto. No doubts? Can I proceed? Yes, please. Yes. No. See, if you are being an institute, you are getting the patent for manufacturing, so process something. So if you are yourself identifying those who involved in your product, who is involved in the manufacturing that, you can go to them, are really very good, directly they will approach to you. If really you are processing something very good, directly by publication, they will approach to you. No need to go. If your process is not that much good, you have to approach and you have to convince them from your process like this, mine is like this, mine is better than them. Then if they agree, they tell you how much royalty you want. That is all evaluation of patent. That is different thing. My work is up to grant. Once it's granted, then it's to public domain. How much evaluation of your IP? For example, I'll tell you. At present, there is no herbal medicine for cancer. We are having allopathy chemo. Somebody, any pharma college or other college producing herbal medicine or syrup or lotion, so any herbal company will run to you directly once it published. They'll tell you, kitna chahiye bolo, then you have to sign it because that medicine is not allowed in the market. No, who is the grantee? If you are having the right, you are the owner of that, not your college. If you are assigning your right to the college, then college authority will speak. Most of the time, what happens in company, especially the people who are working in the Ranbaxy company, the right is with the company only because they are signing column number 12 of Form 1. You also might have signing column number 12 of Form 1 when you are there. You are declaring we are the inventor of this, devoting to the applicant all the rights. So you are not having right, your college having right. If they pay you the some royalty which you are getting, that is, but you cannot fight for that because you already have signed the form that I am the true inventor. I am assigning right to the my college. So you put your name in the applicant name also, in return, then equally right, you can get the benefit of that. So it is left to you. But same, then you are having the equal right. Your college are filing the name on the School of College and Planning, and you are the only inventor, then right is with the all school and planning. Director will sign all those things. But if you are having both times, everywhere you both are required to sign. At that time, you can claim the fund. In teaching faculty, many will give both, but companies, they always take the right to the company owner only. For example, Ranbaxy or Biocon Bengaluru, Shanta Biotech Hyderabad, many companies are, they are having right with them, Reddy's Laboratory. Only we are, because they are paying us, we are utilizing their resources, their labs, everything. So they are the main and we are the student. If they pay, it's well and fine. Otherwise, we cannot fight for them. Any other question? Can I proceed? Yeah, yes. Yeah. See, earlier what happened, we are having very few examiners. But since 2012, we are having a lot of examiners. So earlier, 18 plus 6, 22 months is sufficient for that, but you still may like take lot of time. But now, after 22 months, soon once you get the report, you are filing the reply is okay, within 1 month you are getting hearing, then grant or refusal. Especially some mechanical cases are pending, but not other branches cases. Because mechanical, some problems are still many can, but in other biotech, other all branches, same after 22 months, you are getting the grant after 6 months only. What? Yes. We examine what you reply given, it is correct. Examine. Yes, what we do, that's what I'm telling now. We search your title, what you are given, your invention, we search in our different databases. If you not found anywhere else, then we say that you are qualifying the definition of novelty. Okay. And then we search again some documents. If you are fulfilling the requirement of inventory step or not. And third is a industrial applicability. Then we check with section 3 and 4, whether your method of treatment, whether present of information, whether software as such, what is that? If it is not found in section 3 and section 4, directly you are getting patent without hearing. If any objection, then you are giving a hearing option that you please say your side, what is that natural justice. Otherwise, nothing. Directly you are getting the grant of patent. Search is the main. You can also yourself search primarily before filing, whether my idea is new or not. You can use, but you can search your technology also how it is new or not. Yourself you will know. For example, I told digital mosquito catching bat. Still no one has done, but someone has filed, so I give you the example. Once it's published, I can give the example. And that digital smart scan for the blind people also came. What is that can shows even green signal red, it shows that now green you can walk. They give signal to the blind people. So how much advanced technology. And one of the Nagpur fellow is a professor in the engineering side. He has developed a software tracker. जब हम शूज में साउंड करने कुछ डालते हैं तो बच्चों का साउंड आ जाता है. Like that, he is putting some sort of tracker. Once you got kidnapped or your children yourself, if you press like that, they will that signal. They will give the register mobile number, location of that. So how best it is. So where my child or myself kidnapped, we get the location. It's an invention. So there are many technologies in the market yet to come in the public. Any other question? So while writing the application, as you told, title should be there. What is the content of that? What is prioritized Malto? What problems you are solving? Description of drawings and examples you have to give. Then finally you have to write the claims. Then I have taken simple examples as an composition only. Can just anyone can read composition of ceramic so and so. I have taken same examples. Field of the invention they are given. What is the exact construction they have given? What is the ceramic composition they have given? You can check. You are being a architect, you know all the. So this is the composition of my tiles. Example. Again, detailed description how my tiles I am preparing. All I have given. Examples I have given. Then finally, claim. I means single fellow is claiming. We means 1, 2, 3 are combining. You are claiming the claims. You have to write a ceramic composition like this. Then these are the claims. Again, one of the patent that is dog fishes catching device. Dog, we are using, see how we take our dog to walk we make them to road on the, let the road goes west. But in USA and all, they're using these devices. Somebody got patent for that. You can check in the Google dog fishes catching device. US patent is also there, EP patent also. So their drawings are required. See, drawing giving like numbering also like that. So these are the claims. There are two type of claims. One is called independent claim, another is called dependent claims. Independent means all the essential features should be given in the claim. Dependent claim means additional feature. Whatever you want to get additional feature, my tiles company so and so, wherein my tile ceramic comes 2 to 8%. This is 3 to 1, like that. All the additional feature you have to give in this. Now let us see how to file the patent application. Any person, startup, MSME, anyone can file the patent application. There is no educational limit nor age limit to file the patent application. How to file? Directly you can go to your jurisdiction. As you are from Chennai jurisdiction, you can go there, file, or online filing facility. You can sit in your own office lab, you can file the patent application. Again, jurisdictions like yours is Chennai covers state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, many states. So you have to file in Chennai only. Minimum document required are Form 1, Form 2, Form 3 for foreign filing. Same university for filing the foreign you have to mention. Form 5 to add your friend's name. Form 18 for request for examination. And some forms are optional. If you are going through agent, then Form 26 required for that. Fees is 1,600 for natural person, 8,000 for others. All the details of fees given on the website, please check that. This is online filing fees. If you want to file offline, 10% in addition to that. Any person, you, me, or college people are natural person. Other than it means any company, institute, college is that. Individual name, 2-3 people coming, natural person. So 1,600 only. See, how much less fee is there? Even for the teaching institute, you are having 80% fee concession. How much government giving chance to file the patent, even though our faculties, our students are not filing the patents. That's what very less. That's main motive. Casualties. Yeah, main thing is lack of IPR. But we are spending many more monies on different works, but I urge this director or institute that always at least keep one program IPR for every 6 months for the newcomers, for the students, for the faculty. Definitely they think innovatively. If you are not motivating them, how they will think? As I given many examples. So there are many inventions yet to touch, but we are not going for that. Simple invention, many, but we have to do. Really, if you are conducting, as ma'am told, awareness is a must. Then request for examination, 4,000 for individual, 20,000 for the others. Again, you are having chance to file expedite examination as per Rule 24B. Form 18A is must. While filing PCT, if you are choosing India as an ISA, means International Searching Authority, we search whether your technology new or not. IPA means International Preliminary Examination. We give report on that whether it is patentable or not. Applicant is startup, they can file, or as per 2019 rule, one of the applicant in our group, college group, should be ladies. Then we are giving chance to file expert examination. Again, government institute or college can also file. 8,000 for individual, 60,000 for other. Within 1 year, you can get the patent. There are many examples who got patent within 1 year. These are some timelines. If you pass this timeline, we cannot help it. Provisional to complete should be filed within 12 months. Again, examination should be filed within 48 months. Reply to FR within 6 months. If you are unable to form, take the extension of 3 months, within 9 months by hook or crook. Form 3 every 6 months. Form 5 within month. If you want to withdraw your application, within 15 months. Again, hearing submission within 15 days. Pre-grant opposition, before grant, post grant, 1 year from the date of application. Any interested person can. In this, I told you pre-grant opposition means anyone can oppose. Some other college of architect is filing similar composition. You can say this is very common. You can come as an opponent. If they got the patent by unknowingly, knowingly, the interested person can come. Who is the person interested? For example, Bajaj company is getting patent for their vehicle, then Hyundai company, Tata Motors can oppose. They are called as person interested because they involved in the same business. They are called as person interested. Now, You can check this our website wherein you can know about the patents, design, trademark, copyright. Public search, you can check one column. You can search your project in that, putting the words. Device, what is smart cane for blind people, or ceramic composition, or anything you can put title as you want. Smart shoes for the blind, mosquito repellent composition, mosquito devices, fermenter, any that you can public search. E-filing, you can go there, patent filing, e-signature or digital is required for that. Design only digital, trademark only digital. For copyright, no signature required. All the prototypes, your written work of the architect is copyright. So you can directly log in, create your ID password like train booking, fill the form, upload the document, pay the fees online. 30 days waiting period. For 30 days only is the waiting period for the copyright. After that, if it is new, go for the scrutiny, then you will get in the copyright certificate. If any objection, the hearing notice will come to you, a letter will come to you, have to reply for that. So this is the way of copyright getting filing. Now I'll tell you how to file the design applications. As for design application, any person or institute can also file. Fees is 1,000 rupees for small entity, startup, MSME. Other than that, 4,000 rupees for the design filing. Again, form 1 is all the details you have to fill in that applicant name, class number, address of service, if startup, MSME, form. So all these are requirement for the designs. And we classify your device design into 32 classes, 237 subclasses. For example, these are the different classes of the design. So which class your design you have to classify. If you fail to classify, we are helping you to classify during the examination report. We say, no, your device fall in the food stuff, or if you are filing some mechanical devices or toys, if it is so, which it is, we classify and tell you. And you can check in the Google also. Everything is available in the website. So you can go through that and you describe your design. And we have to write how your design is new. That may be 1 page or 2 pages. You have to write about the my design is like this and that. So I'm claiming design for my teapot. You can check this teapot may not be available in the your home. Maybe there are many teapot. This is new. So how it is new? I have to write name of the applicant like your school of planning so and so name. Total number of seat 8 like front view, back view, side view, bottom view, top view, and perspective. All the photos we have to take the view each corner, and we have to tell my design how it looks, not in the how it works. So, and name of the applicant if you are filing, or if startup MSC filing, their name. If agent is filing, their name you have to give and put the sign. Yes. How you are showing that appearance? Yes. How it looks? Yes. Yes. How you, design means if it is, it should be very beautiful things like cup set. Different cup sets are. If it looks beautiful to her, that's new design. Our examination process will design that. You have to meet. Yes. Examination. We search, ma'am. See, as sir showed many chairs. Neel Kamal chair is there. Ketan fan, Bajaj fan. All design they got registered. Even these earrings, bangles, watches, Timex, Titan, never be copied by any other company. Therefore, they are running like anything. Spectacle designs, all these are different kind of designs. Even sofa set up articles like chair set, you can get registered in the Government of India. But why you are not going? You can take the help of sir. I found sir is very expert in the design. He has given best examples wherein deeply required. We give overall because we are making awareness. But sir has taken very keen example. You can take the help of. If he is not able to, you can call us or mail us. We can help you to identify its new or design. But we search. Even you can search the design. Even tiles design. Your chair standing designs. Yes, many examples just shown. Excellent. Who? Oh. Hmm. Then why can't your institute can publish at least designs? That's what it's that's what you told you na, lack of awareness. First question of yours is lack of awareness because your people are not thinking. See, thinking itself can make your change. No, I can make the design. Oh, see, So no, ma'am, you should file the design. You can take Singh sir is there, Pushpendra Singh, na? So he has nicely explained about design. You can take the help of him. Really, his core work. He has given many examples which are very deeply. Any problem, any field, search for the solution. That itself indicates solution. If water is pouring, you are giving tap, basement, all simple. This podium, this design also. If different, you are giving new design. I told you many examples of pen, pencil, bat, even food products, biscuits, Parle-G, Good Day, Monaco. All designs are different. You can check Monaco by holding hand only. You can check it. Monaco, it's Good Day, because we know that we are using very thin, small round is and Monaco and this thicky with the dry fruits is and this. So by closing eyes, we can. So how they got designed for that company? No one, Good Day cannot be managed for others. Parle-G cannot. That's way of marketing. There is business. So always we should know where the business works. Why Tom and Jerry toys are coming nowadays? When the children are small, after 6 months they are passing, they are not allowed to mothers to work. They are putting at the trolley in front of TV. They are putting Tom and Jerry on. You know, they are asking in the market Tom and Jerry toys only. So one of the biscuit companies thinking the biscuit may come in the same style. So I have given one of the picture of biscuit that Tom and Jerry facing biscuit also. So this way of marketing, that's all. What do people likes? Earlier, as I told you, mobile, we have never thought that mobile will be everyone. 5 members are 5 mobiles are in the home. Who has thought? Need. We have development over able to telephone, mobile phone, then the mobile video call. Now we are no one using, we are Google Meet we are doing, Zoom Meet we are doing. How far we forward? So they need of the day. Therefore, technology required. Therefore, 20 years the term is sufficient. Nokia mobile 2002 mein aaya. Within 20 years we got of the video calling facility and all. So 20 is also not to make the benefit of that. So please think and register your design. Term is 10 plus 5. 15 years the design is with you. You can get the royalty for that. So maybe time is up. Sir is in hurry, Roy sir. So it helps in the encouragement of technology, providing reward as a right. If you are getting the right, you are getting money out of that. Transferring into public property after expired terms. Up to 20 years, you are in the right. Make the benefit how much you want for the patents. Design 10 plus 5, 15 years. Trademark 10 plus how much you want, like Tata, Bata, how long they're in the market. Even GI 10 plus how much you want, you can put. Copyright, life of the author plus 6 days, depend upon the work. So please get the production and be an creativity and be an inventor of that, then definitely you'll be a successful person. So don't wait now. Share the benefit of patent system in school, colleges, universities, even in the public where you get the opportunity. Utilize the resource through organized R&D. Capture the market globally. Earn the profit through protected market. If you're getting design, get it registered, then you come in the market. Sanitizing machine. Jab hum haath niche डालेंगे तो sanitize आए. Earlier there is no. When Corona came, we got. Somebody has got all registered. Samsung TV, Sony TV, both are in the markets. In Dabba was there. Now LED farm, even though they are in the play in the market, because they got patent, design, trademark for all, so that Sony never copy the technology of Samsung nor Samsung connectives. So how long they are in the market? Still my childhood to up tak they are in the market only. No one is coming. So please protect. Make sure that your IPR should be get protected. Intellectual is an asset like any other property. By wishing you all the best for Institute. Hope my lecture motivated you. I am not in teaching field, but I might try my level best to make you understand what is IPR. Thank you. Thank you, Anurag.
Thank you, Bharat Garu, Dr. Bharat Garu. It's a wonderful presentation. Now it is the time for closing ceremony. Now I request Professor and Dr. Ramesh Srikonda Garu on the dais, and Professor Vijayalakshmi on the dais, please, and Dr. Bharat and Sri Sudha Madam and Amitav Sarkar sir, please on the dais, please. Please. It's a really wonderful presentations from all the speakers. And Pushpendra sir also be on the dais, please. So each one is a very, very beautiful presentation. And Madam Sudhasri is talked about the entire IPR system and various different forms of IPR, including the copyright. And she talked about their that institutions, how it supports the academic institutions in terms of patent filing and drafting. And the sponsorship also she is talking about. It's very, very beautifully presented by her. And give her a big round of applause, please. Now, we have already presentation by online. Saha Sahab, Dr. Subrajit Saha, Head Legal IPR, Resolute Group, Resolute for IP. He was talking about the IPR, and he has also insisted us to do some innovations, trademarks, and geographical indications to better for to support the academic research activities. And Dr. Bharat sir, he's talked about entire new the starting from the layman to understand things. See, he spoke about very well about the IPR. He easily understand by the people, even layman. So we give a big round of applause to all speakers who have presented here. And Mr. Puspendra, the internal faculty who has invented 3-2 patents, already filed many more, I think. So he has practically what is he faced the problems, how we solve the issues and all he spoke about. Really give him big round of applause for him. Now it is a time for the audience and participants to give your feedback, and so that we will be improve our things. Or its feedback is very essential for the about the workshop. Now I requesting all participants to give a feedback, saying that how it was. You give your feedback. Any discussions or any questions from your side, please give me that. Anyone? Any questions from your side? The experts are there to clarify. Any questions? Sir. Professor Anil sir.
Hello. Sir, this is a question to Bharat sir. Sir, actually it's eye-opening for SPA Vijayawada, particularly the newcomers, the faculties also, for getting into the how we can protect our creativity and the products and all those things. Sir, is it possible to create a kind of a nodal center in SPA Vijayawada with a mutual understanding of the things?
Please come.
Because since SPA is produce different kind of designs, and not only designs, the thought process also in a more scientific manner also. So how we can protect these things, and if nearby or within that campus, I don't if the director sirs and all, some MOU and all those things, if you have the on-site or within the campus some kind of a nodal center or chamber, something, so everybody they can go and they can make their wish to happen in a more protected manner and all. Yeah.
Yeah, really you are asking, sir. But as per the Government of India, it's ministry matter. Government of India has already established 4 offices. They're telling one should be in South Hyderabad, but still not. Since long back, we are hearing that one office should be in Bangalore or Hyderabad, but still no result has outcome, because since 20 years I'm in the field. All these opening offices is of the matter of Ministry of Commerce and Industry, and head of the office CGPD means Controller General of Patent. So you can write the mails to them on behalf of your government. So they may think of, as we are the officers but working in that office, nothing in our hand. We can make you, guide you, help you how to file all, but we cannot head of the office, or like ma'am's office or TIFAC, some many are there, they can help you out, but not as being officer. You all request should go to the ministry and CGPDM. Definitely they may consider, because many people are doing good. So let us hope for that. Just start by writing the mails from your institute. Thank you. Any other questions? Let me know.
Any other questions from the audience? Participants.
Sorry to say that It's actually nice. In a way, it was nice that Dr. Bharat, his train got delayed because I was also not here for the first 1 hour. I was with an external. So after listening to all the lectures, I feel one thing. All of them said something which was common to all the lectures, but all the lectures felt different. We learned something or the other new from every single lecture, which means I
Thank you, ma'am. Any participants? Yeah, please. Ram Krishna.
Happy healthy evening. Good evening, sir. I'm from KL University. I'm doing MSME and government. We have one concept of government. We are funding with patent filing and startup incubation funding, and we have doing all these copyrights and trademarks to all the. We have IP Yatra also next December 1st week, ma'am. I just want to know government. What are the schemes we have in filing patents under the government? What are the advantages we have from government? I just want to know from you. So mainly, I just want to know patent filing, how we can get benefited from MSME Uddimadar. So many of the people don't know what is MSME Uddimadar. So can you show about the advantage of MSME Uddimadar, please?
Yeah. Yeah, I can answer your question.
Yes, ma'am.
Yeah. Usually for MSME, you do have a rebate of 80% compared to the other small entities. The startups, the MSMEs, and the educational institutes. There's a new framework which has been brought out by the government of India so that they are encouraging all the innovators to come front, and also apart from the fee rebate, you also have an fast track prosecution. For example, the general timeline taken for the publication is 18 months, and from then they have to wait for another 48 months for the examination. But the MSME startups and the universities, institutes, they can go for an expedited examination. Whereas the other people, the entities cannot go for that. Okay. But you do have that provision. That is the first advantage. And you ask like what kind of support you're going to get from the government for the filing, right? So you have IPFC centers, that is intellectual property facilitation centers, in each and every state. For example, in Andhra Pradesh, you do have an IPFC center in Vishakhapatnam, that is NRDC. NRDC is one of the intellectual property facilitation center in Vishakhapatnam. So we do facilitate the IP filings. It's not only for patent, for all the IP filings. If you approach NRDC, we will provide you both technical and financial assistance for filing of IP. But since it's a government scheme, we do have our own guidelines, and the number of applications which we provide to each number will be restricted. For a single applicant, we cannot go for 10 or more, right? So there'll be like a limited number, two to three applications we can support for a single university or a single inventor. That's how we do support. I think it is clear, right? Do you have any other questions? Okay, thank you.
Hello.
Okay, good afternoon, everyone. So we will start with the certificate distribution. So first one is Dr. Sambashiva Rao Tadepu. Yamnini Liktha Madhav Sai. Mallika Paravatini. Next is Mallika Pravatini. Then B. Lata Pani. Dr. Pulichella Mallika Arjuna Rao. Ms. Pooja Inayar. Then Y. Srinivas Raju. Not there. Krishna. Pooja Nair. Next is Dr. Arun B. Paritala Venkata Krishna Rao. Now our faculties, Dr. Prashanti Rao. Mr. Rajiv R. Dr. Amitav Sarkar. Ms. Ekta. Mr. Valiappan. Ekta. Oh, list ke saath. Then Valiappan sir. Deepak Kumar. Dr. Iyer Vijay Lakshmi. Mr. Anil Kumar.
Never speaks, ma'am.
Mr. Gopinath. Mr. Malvi Govindan. कृष्ण जी योगानंद जी नहीं है, योगानंद जी नहीं है, ठीक है। भानु प्रकाश रेड्डी। Sorry. Now for students, Shiv Narayan Mohapatra, Sanskriti Vashisht, Sanskriti Maulashri Agarwal, no, she's not there. Amisha Bansal, Kavya Shekaran, Hitesh, then Santeya, Kritika, Aluri Hashni Shri, Saikat Ghosh, then Sakhi Diwali, Tanmay Atre, Shijini, कृष्ण जी वो भी नहीं है, शिजनी हरीश नहीं है, then युगदेव नहीं है, मिलन दीन, रोहन कुमार माली, रिश्वंत, आदित्यराज, विनय झा, एंजेलिना मैक्सिया, Gwenwe Latima, then Hetvi. Okay, Krishna ji, this is एक second. PVS Ramkrishna, Tandav Krishna, then Dr. Y.S. Rao, आंसर नहीं है, मिस्टर विश्वनाथ,
Yeah, you validate the same word, the same message निकाला. Now I request all dignitaries on the dais. Now it's a time for vote of thanks. Vishwanath, that is inaugural vote of thanks. This is the overall workshop vote of thanks.
So, good evening, everyone. So again, it's a wonderful opportunity for me to give the vote of thanks to this National Workshop for Intellectual Property Rights. I would like to express my gratitude to our director, Dr. Ramesh Srigonda sir, for giving us this opportunity to make this event a grand success. Yes, sir. And to Dr. Mayas Rao sir for giving me this opportunity to organize this and guiding me in having this into a wonderful event. My heartfelt appreciation goes to our chief guest of honor, Dr. Bharat Suryavanshi sir, Miss Sri Sudha ma'am, our faculty, Pushpendra sir, for giving their valuable information, knowledge to us and making this event a grand success. I would also like to thank the participants who have come from various institutes and our own students for engaging in this event. And thank you. I like to extend my support, warm wishes to and my heartfelt thanks to my colleagues from library, Krishna, Ramakrishna, and also the IT department, electrical department, and everyone who has supported us in organizing this event and making it in yes, including housekeeping, for making this a wonderful event and helping us in all sorts of way. Thank you. And with this, yes. So I know many are librarians from various parts of Andhra Pradesh have come here. Thank you for accepting our invitation and coming here. I hope we have your support in future programs also. Thank you, sir. Thank you, ma'am. And I also like to give my appreciation to our administrative and financial team for their full-on support for our future events. Thank you. Thank you. And we'll start with, we'll raise for Janaganamana.
Thank you all. Chai. Please join for snacks and tea. Please.